A coalition of mayors and activists from around the country have scheduled a march and rally for Washington, D.C. this coming Saturday. The event is titled Save Our Cities, Save Our Children. Organizers say it is intended to send a message to Congress and the administration concerning the needs of cities across America. C-SPAN plans live coverage of the event on Saturday, and you can check our program schedule for the exact time. For a behind-the-scenes look at the United States Capitol, C-SPAN offers Exploring the Capitol, a self-guided tour through the halls of Congress. With more than 70 pages, Exploring the Capitol examines the architecture, art, and history of the Capitol building. From the laying of the cornerstone in 1793 to information on hours of operation today, you'll find it all in Exploring the Capitol. To receive your copy, send a check or money order for $5.95, plus $2 shipping and handling to Exploring the Capitol. C-SPAN Publications, 1616 Main Street, Lynchburg, Virginia. The zip code is 24504. Members of the Senate Governmental Affairs Committee met on Capitol Hill today to consider Senate Joint Resolution 282, the Assassination Materials Disclosure Act of 1992. The legislation concerns the release of documents pertaining to the November 1963 assassination of President John F. Kennedy. If approved by Congress and signed by the President, SJ Res 282 would create an independent review process to speed the release of thousands of classified government documents dating back nearly 3 decades. The Justice Department last month released a letter expressing strong opposition to the legislation. That letter raised several objections, from questions of constitutionality to a need to protect intelligence sources and methods. The Justice Department's opposition comes despite previous FBI and CIA statements favoring release of the assassination files. During the next 4 hours, we will hear from several witnesses, including CIA Director Robert Gates and FBI Director William Sessions. This hearing was held inside at the Dirksen Senate Office Building, and we will now bring you our coverage of today's proceedings, gaveled to order by the committee chairman, Democratic U.S. Senator John Glenn of Ohio.
Hearing will be in order. The bill before us today, SJ Res 282, the title is the Assassination Materials Disclosure Act of 1992. The legislation was introduced by Senator David Bourne and Senator Arlen Specter. Identical bill was introduced in the House of Representatives by our colleague, Representative Louis Stokes. The legislation would require the government to release records to the American public which are, and I quote, relevant to the assassination of President John F. Kennedy. The bill would establish an independent review board within 90 days of enactment, and this board would work as quickly as possible to release the records to the public through the National Archives and the Government Printing Office. The bill creates a strong presumption on releasing documents. The onus will be on those who would withhold documents to prove to the review board and the American people why those documents must be shielded from public scrutiny. It is also important to stress that the legislation does not authorize any new official investigation of the assassination. Its only purpose is to create a process by which the American public may be given the most complete access to review relevant records and to make their own observations and assessments. The committee's work in the hearing today is likewise limited to this purpose. This bill is a result of a climate of suspicion and distrust that has grown over the years regarding the official explanation of the assassination of President Kennedy. It's a climate nurtured by many books and articles, television programs, and the recent movie JFK. Disclosure of information is the only reliable way to maintain the public trust and to dispel distrust. Those of us who knew President Kennedy personally and remember where we were when we learned of President Kennedy's assassination must now exercise our responsibility to the next generation of Americans whose historical knowledge of the assassination of President Kennedy will be significantly improved by the release of these records. Ironically, it was President John F. Kennedy who first required scheduled declassification in the release of executive branch national security information. Declassification schedules remained in effect until President Reagan eliminated the requirement in 1981, and President Bush persists in that same practice today. It is likely that more government documents related to the Kennedy assassination could have been released over the past 12 years if declassification was still a priority. It is also fair to say that the 1986 amendments to the Freedom of Information Act, including broad law enforcement exemptions, have narrowed the release of Kennedy assassination records by the FBI. The public interest in the history of the assassination of President Kennedy has been seemingly insatiable. In one noted bibliography, a total of 5,134 books and articles, reports, films, or television programs were produced on the subject between the years 1963 and 1979. The Library of Congress has over 250 holdings on the subject. The FBI continues to receive reports and allegations and requests for further investigation. Indeed, as I believe Director Sessions may testify today, the FBI has recently located and interviewed 2 of the 3 hobos who were identified as witnesses of the shooting, as well as 7 Dallas police officers who were not previously interviewed by government investigators. So the speculation about the assassination of President Kennedy may be more cruel than the truth itself. It is arguable whether the disclosure of new information will dampen the speculation. But I hope that the breadth of information made available will answer many questions and provide many history lessons. I view the committee's mandate as determining whether the process for review and release of the records is fair and appropriate, and that exemptions, when needed, must be kept to a minimum. The Department of Justice has told the committee that it may recommend a presidential veto of the bill as written. And I hope we can find a way to construct a process for release of assassination-related records that will be efficient and effective, will gain the confidence of the public, and will address concerns of the Justice Department that are legitimate. The authors of the bill are to be congratulated for working quickly to propose an independent and accountable mechanism to release records related to the assassination. However, we must carefully consider all the parameters of the bill. I believe the major issues include, first, how will agencies and others who hold records define the universe of, quote, relevant Kennedy assassination materials? It is important to be able to go beyond the frame of reference of previous inquiries of commissions and committees, but the question must be asked, where will the search for documents end? In other words, what is relevant? Second, the definition and search for relevant assassination material also raises important questions of human resources and costs to organize and make material available to the review board. How much will this cost? We know the Warren Commission had a tab of about $10 million. Early investigations were not inexpensive. Third, what is the best mechanism to govern the review and release of records in an independent, accountable, and credible manner? The tension between management and public confidence in the process cannot be overlooked. However, it may be important to simplify the process. The bill proposes a five-member review board with an executive director and staff. Are we creating too much of a machine, a Rube Goldberg machine, or are these layers even necessary? Fourth, we must ask why the bill, which acts in the name of openness in government, also exempts the review board from the Government in the Sunshine Act, the Freedom of Information Act, the Administrative Procedures Act, and judicial review. Fifth is the issue of standards for postponement of disclosure. I strongly believe that the government should practice disclosure of information as the rule unless there are demonstrable reasons for protecting the information. It is important to emphasize that while hundreds of thousands of pages, indeed we may even have millions of pages of material involved here that will be released, the bill contains national security and privacy exemptions and withholds personnel and administrative records relating to past official inquiries. I personally believe that the agencies and the Congress which hold Kennedy assassination records should not wait for the passage of legislation and the resolution of all issues in this bill before releasing documents. It is my intention to move legislation through the committee as quickly as possible, but regardless, it will take time for whatever authority is created in statute to become assembled to establish procedures and begin its work. We will hear today how ready key agencies and congressional officials are to release their records. If even some of the material can go out the door without further adjustments, then let's give the public access now. The review board, or whatever authority is created, will certainly have the opportunity to face the more difficult issues shortly thereafter. Today we're fortunate to have several experts and authorities to discuss these issues. These include the authors of the legislation, as well as the Director of Central Intelligence Agency and the Director of the Federal Bureau of Investigation. We are grateful to have our other witnesses as well. Among them is Attorney James Lesser, the President of the Assassination Archives and Research Center. Mr. Lesser's work represents the track record on public access to Kennedy assassination material under the Freedom of Information Act, and he will speak to the nature and limitations of current access arrangements. We also have two prominent 20th century historians, Professor Ernest May of Harvard University, Professor Ethan Theoharis from Marquette University. Each possess very extensive experience regarding the federal records of the intelligence and federal law enforcement communities, and we welcome all of you to the committee and to our hearing today. Senator Roth.
Thank you, Mr. Chairman. Over the course of the last several months, I've received numerous letters from concerned Delawareans favoring the disclosure of material relating to the assassination of President Kennedy. With nearly 3 decades having passed since President Kennedy's tragic death, I hope that all of the relevant material will be made available to the public in a responsible and expeditious manner. Now, it's my understanding that the CIA and the FBI are in the process of reviewing previously undisclosed assassination records for a possible disclosure to the public. I look forward to hearing the testimony of our witnesses this morning regarding the progress of this review. As we discuss the release of additional classified information, we should not lose sight of the fact that the number of documents that have now been made available to the public runs into the hundreds of thousands. Almost all of these documents have been released without redaction, and only a small percentage have been reclassified and withheld from public scrutiny. I'm also told that about 98% of the Warren Commission documents are already available to the public through the National Archives. The fact is that much of the JFK assassination material is already available to the public and has been for many years. Even so, nearly 30 years after President Kennedy's death, there needs to be additional efforts made to ensure that the remaining assassination material is released to the American people in a timely manner. And that, of course, is why we're here today. While I'm not convinced that the resolution which we are considering represents the best means to assure that the remaining records are disclosed expeditiously, there clearly needs to be a re-examination of classified files with an eye towards further disclosure. The American people have voiced their support for such efforts. It's time that we restore the trust and confidence of the American people and their government to which they are entitled. Although objections to the mechanism of review have been raised on both practical and legal grounds, I think we're all in agreement with the basic purpose of the resolution: to secure the expeditious disclosure of records relevant to the assassination of President John F. Kennedy. It's a laudable one. And it's hope, at least my hope, that ways can be found to streamline the review process, and I'm particularly interested in comments from our witnesses in this regard. I do share some of the concerns outlined by the administration and believe that the procedure we adopt must not prove more cumbersome and costly than necessary. Indeed, the establishment of a complicated mechanism of review may actually inhibit the expeditious disclosure of assassination's material. One of the matters that I am going to be interested in is why we cannot build on our freedom of information rules to secure the adequate release of other material. Now, Congress has the power and ability to act on its own to release any and all documents within its possession and control. At least one committee in the Senate, the Church Committee, and one committee in the House, the Select Committee on Assassinations, maintain classified files pertaining to the Kennedy assassination. Rather than establishing a new bureaucracy to process this information, why not release the information directly and immediately to the public? While we might never know the whole truth behind the tragic assassination of President Kennedy, the American people deserve to reach their own conclusion, and I support the efforts here today towards that end. Thank you, Mr. Chairman.
Thank you. Senator Levin.
Thank you, Mr. Chairman. 28 years have now passed since this country first experienced the shock and the grief of the assassination of President Kennedy. That day in Dallas is seared in our memories, and the recent popular movie has brought back the pain and the loss. It has also played into the doubts in the minds of many Americans as to the effectiveness of the federal government's investigation of the assassination and over how forthcoming the government has been with the information collected regarding this terrible act. Since the death of President Kennedy, we have had the Warren Commission, the House Committee on Assassinations, the Church Committee, and the CIA and FBI investigating various aspects of the assassination. And yet, as we sit here today, major questions still remain in the public's mind. The American public has the right to put this assassination investigation behind it with the confidence that we know as much as we can know that its government conducted a full and responsible investigation, that the findings that have been made are the most reliable and responsible ones. That can't happen unless and until the documents involved are made available to the public to the fullest extent possible. And we must make that happen. The bill that we're considering today is our best hope for doing that. It is a strong presumption in favor of disclosure. It casts a wide net in its coverage of relevant documents. These elements are important in order to achieve the legislation's purpose, laying to rest as many doubts as possible about the investigations of President Kennedy's assassination. I know that there are some concerns about specific provisions in the legislation. I have some of those concerns myself, but the bill as a whole is thoughtfully drafted. The truth, the whole truth, is to be cherished and is of inherent value historically and for our national psyche. One of the effects, parenthetically, of keeping these documents confidential is that some people have been able to sensationalize and exploit this tragic event and to play to America's worst fears and doubts. We need to get the real record to the American people so that they can judge for themselves. I commend our colleagues, Senator Bourne, Senator Specter, Congressman Stokes, for taking on this issue. I look forward to the discussion today. I'm proud to co-sponsor this bill because I think it moves us finally in the right direction in a very, very strong way.
Senator Pryor.
Thank you, Mr. Chairman. I have a statement I would like submitted for the record, Mr. Chairman. I will not deliver the entirety of that statement. Also, Mr. Chairman, I have an article from the Washington Post dated June 18, 1979, that I would ask the committee unanimous consent to put in the record at this point. And, Mr. Chairman, the reason I'm putting this particular article in the record, which was on page 1 of the Post, was the fact that this, I think, demonstrates what can go wrong when the public is not allowed to know what is going on. And this article relates to a CIA employee breaking into the House of Representatives Assassinations Committee file in June of 1979. And it also, I think, points up the fact, Mr. Chairman, what can happen when we basically put a lid on personnel file, administrative decisions, which was the case in point here in 1979. I think when our government spies on other government entities like the House of Representatives or the Senate, what have you, I think it's time to do something, and I think that time is now. And I commend the members of the House and Senate who have involved themselves in this matter in bringing this to our attention today. I think all of us know today in this room that eventually we're going to know the facts, or at least do everything we can to get the facts. So my position is, if we're going to do it, let's do it now, and let's support this resolution. Thank you, Mr. Chairman.
Thank you. Senator Lieberman.
Thank you. Thank you, Mr. Chairman. Almost 30 years have now passed since the assassination of President Kennedy on that terrible day in Dallas. Like so many other Americans, I remember that day as if it were yesterday, where I was, what I was doing, and how, as a 21-year-old college student who had already been drawn conclusively into a life in public service, in large measure by the Kennedy administration, how shocked and stunned and heartbroken I was at hearing the news of that assassination. Those shots have reverberated through our personal lives and indeed through our national history over these last 30 years. The story of the assassination is one whose concluding chapter seems never to be written. And now, in our time, it is the Oliver Stone movie JFK that has brought the tragedy and its unanswered, unconcluded chapters back to public consciousness. We ask ourselves many of the specific questions that were asked 30 years ago and then over again since then. Was there a single bullet? Was there more than one gunman? Was there a man on a grassy knoll? Was there a conspiracy? Was the CIA or the FBI or the mob or Fidel Castro behind the assassination? Who exactly was Lee Harvey Oswald, and what brought him to Dallas? There are times, Mr. Chairman, I think that as we ask these specific questions, we continue to pursue them because we ask ourselves a more general and unanswerable question, which is not just how did the assassination occur, but how could it have occurred? Why did it occur? Why did something so seemingly irrational interrupt the course of our history? The broader questions are beyond our ability to answer. But clearly, many Americans believe that critical information needed to answer the more specific questions still lies in government files, shrouded by secrecy, buried in a warehouse like the Ark of the Covenant in Raiders of the Lost Ark. Opening those files and providing broader access to the public will no doubt provide fuel for some of the sensationalists who live off of this tragedy. But it will also allow serious researchers and historians the opportunity to finish writing not only the history of the assassination, but the history of the Kennedy presidency. Now, Mr. Chairman, I don't think to proceed with this disclosure bill, it's necessary to believe that the Warren Commission was right or wrong, or that there was or was not a conspiracy. What is important is that as many files be made public as soon as possible, so that we may in this way attempt to undercut the general and specific mistrust that so many people in our country have about our government. Recent events in the former Eastern Bloc, the former Soviet Union, have shown us once again that in a nation of the people, by the people, and for the people, it is openness and not secrecy that ultimately fosters trust and faith in government. I understand, Mr. Chairman, that there are arguments for keeping some files closed. They go from the general to the very specific and detailed and technical. There are those who say we need to respect both legitimate national security concerns and the privacy of people who may still be living, as well as the privacy of their families. But I think, Mr. Chairman, we also need to refocus our lenses here, and as we weigh privacy questions, weigh them against the public interest in disclosure. As we weigh national security questions, that we reflect the fact that we live in a world that is very different than it was 29 years ago when this assassination occurred, different than it was 2 or 3 years ago, in fact. We're no longer fighting the Cold War that was the context for many people's understanding of this assassination. Today, Berlin is the capital of a united Germany. The Soviet Union no longer exists. And while Fidel Castro remains in power in Cuba, his days surely are numbered. At a time when our former enemies in the Stasi and the KGB are seeing their files open to scrutiny, it is time for us to do a lot of the same. Mr. Chairman, this committee has an important task ahead. We've got to do what we can to open as many files as we can as quickly as possible. We've also got to do it in a way that assures as much legitimacy to the process of attempting to answer the questions that still plague the American people. We've got to do that with care and with adequate direction and specificity. That's the ultimate goal, as I see it, of this bill. And Mr. Chairman, I look forward to working with you on this matter.
Thank you very much. Senator Cohen.
Thank you, Mr. Chairman. I spent 8 years on the Senate Intelligence Oversight Committee, and I must say the temptation is very great for me at this moment to see Director Gates in the audience, Director Sessions, my colleagues, Senator Boren, Specter, and Congressman Stokes, to take this opportunity to give a long dissertation my thoughts about the Kennedy assassination. But in view of the fact that we have such distinguished guests in the audience, I'm going to resist that temptation. Just to add a footnote or so to what Senator Lieberman was saying, I think everyone in the audience today, probably without exception, could tell you exactly where he or she was on that day that Jack Kennedy was assassinated. We speak quite easily about defining moments. That was a defining moment in our history. Not only was a president murdered, presidency destroyed, but I think a sense that government was not an it was a we back then. It was not something distant and remote and antagonistic and oppressive. It was a sense of we. What could we do to make life better? Not what was government doing to us. And I think today that a great gulf exists between the people, their elected officials. Doubts about this particular matter are another symptom of that. And so I think what the purpose of the investigation is right now, what it has to do is to ask some questions. Why does information need to be withheld? At this moment in time, what compelling interests are there for the holding back of information? Are there legitimate needs in this respect? Who and what is being protected? Which individuals, which agencies, which institutions is in need of protection? And what national security interests still remain? I think those are the essential questions that we can raise during the course of this inquiry. And hopefully we can forge some legislation which will accomplish the goals that Senator Lieberman has just outlined, to get as much information out to the public as quickly as possible. Thank you, Mr. Chairman.
Thank you very much. First witness this morning, Senator David Boren. David, if you'll lead off, we'd appreciate it.
Thank you very much, Mr. Chairman. I very much appreciate the opportunity to appear before the committee to discuss with you Senate Joint Resolution 282, the Assassination Materials Disclosure Act of 1992. The purpose of this legislation, as has already been indicated, is to provide for a comprehensive process ultimately leading to the release of all materials held by the United States government regarding the assassination of President John F. Kennedy. Congressman Lewis Stokes, the distinguished former chairman of the House Select Committee on Assassinations, has introduced identical legislation in the House of Representatives, and he is here with me this morning. I'm particularly pleased, Mr. Chairman, to have you as an original co-sponsor of this legislation, along with Senator Cohen, Senator Levin, my colleague Senator Specter, who is also here. We've had at least 4 substantial federal government investigations into the Kennedy assassination. The first conducted by the Warren Commission appointed by President Johnson in 1963. The second by the President's Commission on CIA Activities, known as the Rockefeller Commission, in 1975. The third by the Senate Select Committee to Study Governmental Operations with Respect to Intelligence, known as the Church Committee, in 1975 and 1976. And finally, the extensive investigation of the House Assassinations Committee in 1978 and 1979. Each of these investigations, particularly the Warren Commission and the House Assassinations Committee investigation, produced long, detailed public reports concerning the Kennedy assassination. In addition, literally hundreds of books and articles have been written on the subject. Yet, as has been indicated by the members this morning, almost 30 years later, questions remain. The recent release of the controversial film JFK has raised them again, suggesting that answers may well lie in the assassination records and other materials that remain sealed by our government. Even prior to the release of this film, in fact, there were diligent efforts made by researchers as well as concerned legislators to open these files for public review. Mr. Chairman, I do not know what all of these files contain. Specifically, I do not know whether they contain information that would call into question or undermine the findings of the previous investigations or not. But it seems to me the time has come to open these files to the public and let them speak for themselves. Let historians and scholars and journalists and the people read them and draw the appropriate conclusions. As a general principle, the intelligence community should make available its records after the passage of a reasonable amount of time when current sources and methods would no longer be compromised. The American people have a right to assure themselves to the greatest degree possible of the accuracy of the historical record of our government. We've seen with the collapse of the Soviet Union the results of what happens when a government tries to, in essence, invent history and impose an inaccurate record on the people. The timely release of all documents of historic value and importance also helps to assure that even the most secret programs of our government will be operated in accordance with basic American values. Current intelligence operations will be even more carefully conducted when it is recognized that they will be scrutinized by the public during the lifetime of many of those who administered these programs. And I'm very proud of the fact the chairman knows as a member of the Senate Intelligence Committee that we have been working in a cooperative partnership with Director Gates on a new process at the Central Intelligence Agency to speed the release of other documents of historic importance. While national security and personal privacy concerns may yet retain some validity in a very few isolated cases, it seems to me that with the passage of time there should remain few objections to full disclosure. I believe it is time to review these records not in terms of the old assumptions, but rather in light of the need for openness and to encourage confidence in the government. We need to assure ourselves of the facts, that there is not information lurking somewhere in the government that would shed new light on what remains perhaps one of the most heinous and enigmatic crimes of this century. With regard to the Justice Department's April 27th letter to you, Mr. Chairman, I must say that I found it very unfortunate that the department chose to take what I found to be an extremely hardline position in opposing many of the key provisions of this resolution. Rather than showing the flexibility needed in this unique circumstance to deal cooperatively with the Congress on a matter, that's serious concern for many Americans. The Justice Department chose instead to reassert familiar claims of executive privilege and all of the other reasons asserted over the years to block the release of government information. Let me say, if the process used by the Freedom of Information Act were successful in releasing these kinds of documents, they would already be released. The very fact that documents are classified usually prevents the release under the Freedom of Information Act, and indeed it does not have the same kind of balancing standard with a presumption for openness and release as we have in this legislation. The whole point of this legislation is to create new criteria and new procedures to maximize the release of information hitherto withheld by the government. The old laws and old procedures that have been tried for the last 30 years and have not produced the type of disclosure needed to restore the confidence of the American people are simply not the procedures to follow in this case. It seems to me that just this once, where the public policy interests in full disclosure of these records is so apparent, the Justice Department could dispense with its usual to the last man defense of executive branch prerogatives and help us deal with solving the problem. Hopefully the committee will yet be able to obtain executive branch cooperation and move forward with this process. And when I say executive branch, let me hasten to say I'm not talking about the CIA, the FBI, and others who hold many of these files who've indicated on an agency-by-agency basis a willingness to cooperate fully. The public expects action in this matter. Many letters and postcards and telephone calls to all of our offices demonstrate. Having said this, there are in fact several points raised by the Justice Department's letter and by private citizens in touch with me, which I do believe merit further consideration by the committee. Now, these are discussed in my written statement, but I'll just mention one or two of them now. One involves setting the boundaries of, quote, assassination material. The joint resolution defines the term assassination material as a record that relates in any manner or degree to the assassination of President John F. Kennedy. Given the wide range of theories that have developed as to who killed President Kennedy and why, many types of records arguably relate in some way to the assassination. What records regarding, for example, Cuba, Vietnam, and organized crime should be covered? This matter requires careful consideration. The Justice Department urges a substantial narrowing of the definition of assassination material, apparently to only those records that on their face directly concern the assassination. I'm concerned that this formulation might be too narrow. There's a widespread public suspicion that some sort of conspiracy led to the murder of President Kennedy. If we go out of our way to avoid records that might shed light on activities linked to such an alleged conspiracy, we might make little progress toward assuring the public that they have the full story. On the other hand, if we err on the side of too much inclusiveness and as a result learn more about the operations of our government and our foreign policy in the early 1960s, I think we'll benefit. My only concern would be that if the search became so broad, it could delay action on the release of documents clearly germane to the assassination. But where records have already been segregated, such as the executive branch materials obtained by the House Assassinations Committee, full review is probably appropriate. I do, however, suggest the committee, either in the joint resolution itself or in report language, set more precise parameters defining assassination material, or else direct the review board to do so promptly after it's established. Otherwise, we might end up with widely varying interpretations by the various records agencies and committees as to what documents should be forwarded to the review board. Finally, very briefly, one other issue I think is before the committee that the committee certainly would want to address. We faced a very difficult choice drawing this resolution and deciding who should appoint the review board. And I'm aware that the committee is looking at other alternatives. I'm certainly open to this myself, but I wanted to give you at least some idea as to why we came out where we did. Given the allegations of government cover-ups and the potential for perceived conflict of interest, allowing the President or Congress alone to appoint the board did not seem appropriate to several of us who authored this resolution. We settled instead on the special three-judge federal court division that appoints independent counsels for criminal investigations. If the committee concludes that this approach is undesirable, I would offer two other alternatives for consideration, conceding that both are themselves susceptible to possible constitutional objections. The first would be for the President and the leadership of the House and Senate each to appoint a given number of the board members. Each body has interests in and a responsibility for certain records at issue. I would not make these appointments subject to Senate confirmation since they're not policy positions and confirmation would only delay the task at hand. The second alternative would be the approach suggested by the ACLU to adopt some variant of the formula used last year by Congress in establishing the Advisory Committee on Historical Diplomatic Documentation in the State Department, namely to have the President appoint based on specific criteria, for example, background in certain disciplines, with most of the members coming from lists submitted by designated professional associations. So these are alternatives. I want to thank the chair and again thank the members of the committee for allowing me this opportunity to express my views on this very important matter, and thank you also for your timely consideration of it.
Thank you very much. Senator Specter.
Thank you, Mr. Chairman. I'm pleased to join my colleagues, Senator Bourne and Congressman Stokes, this morning, and note the presence of 5 members of the committee, indicating the importance of the subject and the thoughtful parameters which have already been established by the committee on the range of issues to be considered. I believe that public confidence requires full disclosure of all the Warren Commission records, and have felt that way since I served as assistant counsel to the Commission in 1964. My own role related to what was called Area 1, which involved the ballistics and trajectory and wounds on the President and the Governor, and all of the records were disclosed at that time with the exception of the photographs and x-rays. And I felt strongly at that time that the photographs and x-rays should have been examined by the Commission and staff, and that was not done. In some discussions here this morning with Congressman Stokes and Director Sessions and recounting that circumstance, they expressed surprise that even the Commission and the staff did not have access to the photographs and x-rays. We did have the direct testimony of the autopsy surgeons so that the photos and x-rays were corroborative, but I thought very, very important corroboration. I did not recollect until I was called to testify before the Stokes Committee in 1977 that I had written a very strong memorandum in 1964 on that subject. When the Commission was in the process of finishing its work, there was even a question as to what the Commission would do by way of publication. And there were those on the Commission itself who thought that it was too expensive to publish the record. And finally, some of the staff went to the congressional members who were used to having so much voluminous material published in the congressional record. We had 2 senators and 2 members of the House, Congressman Boggs, Congressman Ford, Senator Cooper, Senator Chairman of the Armed Services Committee, Senator Russell. And the members were very, very used to having everything published. And we then published 17,000 pages in 26 volumes in addition to the full report. And that material has provided the principal source for the many, many books which have been written about the Warren Commission. And there has been intense public interest, and I have seen it firsthand with hardly a week going by when I have not been asked about the subject, either in social conversation or speaking in an open house town meeting or in high schools or wherever. And there is no doubt that the issue has reached a crescendo at this time and that prompt action ought to be taken. On the first day we were back in session, I called Congressman Stokes because he had chaired the committee in the House, and I had had the involvement, as I've noted, as a assistant counsel many years ago, and discussed putting forward this kind of a joint resolution, and then worked with my colleague, Senator Bourne, on the subject. I personally know of any material which ought not to be released. And I think when you deal with the issue of heavy presumption, that's the way to approach it. And perhaps there is something that ought not to be released. But I think that it ought to be, there should be a very, very, very strong case made before any information is withheld And I would have a doubt expressed here this morning that any information ought to be released. I'm well aware of the considerations of national security and foreign policy and intelligence and law enforcement, working on the Intelligence Committee and working on Defense Appropriations Subcommittee and having experience in law enforcement. But we have now seen the end of the Cold War. We do not have the confrontation between the United States and the Soviet Union, so any of those factors are of a bygone age. We're dealing with events almost 3 decades old. It is hard to see how any of the law enforcement issues would be critical, or the foreign policy considerations, or the intelligence matters. And I think it is very important to put it all out there and let the chips fall where they may. Public confidence is very, very important. I personally am confident that the Warren Commission conclusions will stand. But if they don't, so be it. I know that when Chief Justice Warren convened the staff in his first meeting, he said bluntly, we have one client, and that is the truth. And Chief Justice Warren was importuned to take the commission chairmanship under very unusual circumstances. President Johnson had first sent the Solicitor General, Archibald Cox, to see him, and then he'd sent the Deputy Attorney General, Nicholas Katzenbach, to see him. And Chief Justice Warren had declined on both occasions, according to what the Chief Justice told the young lawyers which were assembled at the first meeting. And it was only after President Johnson called the Chief Justice into the Oval Office and asked him to take on the job, and the Chief Justice explained his reasons why he thought he should not, that the President, as the Chief Justice related it, said, would you turn down the Commander-in-Chief's request to put on the uniform of your country in time of national peril? And Chief Justice Warren told the staff, he said, I could not decline that, and they undertook the job. But he didn't have any concern about where the investigation would lead. Wherever it would lead, so be it. And then the President appointed the congressional members, and John McCloy and Alan Dulles, and we had a 7-member commission. And the commission then sought to find people outside of government. And they went around the country, picked lawyers from New York and Chicago and Denver and Los Angeles, and 2 from Philadelphia. And off we went to do the job. The single bullet theory has been much debated. It has been upheld by Congressman Stokes' committee, been upheld by independent studies, and I think it is correct. But if it isn't, so be it. Let someone come forward and disprove it. Was there a conspiracy? It's not possible to prove a negative. Can't be done conclusively. But I believe had there been any evidence of a conspiracy, we would have known about it long before today. From my experience, nothing is a secret. And had there been a conspiracy, we would have known it. But if there was a conspiracy, let it all come out and let the facts be disclosed. I have studied the Justice Department objections, and while I think they have some basis in legalisms and doctrine, I do not think that they ought to stifle or restrict this resolution being enacted. When you talk about what ought to be available in terms of deliberative materials, I don't believe the executive branch has any constitutional claim to making that determination over the Congress. When you talk about law enforcement matters, again, I think that's a matter for congressional determination as opposed to constitutional executive authority. When you talk about national security, that is the province of the President, and the President can exercise it here if there is any basis that he sees, but I think it ought to be very, very restrictive. I believe there ought to be judicial review. I think that the exemptions in terms of the Freedom of Information Act and the Sunshine Act are not well taken. You can do them one way or another. I would prefer to see those acts apply, but I would certainly prefer to see judicial review applicable. I believe there is nothing like judicial review where all of the actions are taken before a judge in a court in accordance with due process and analyzed and considered in a way which we cannot possibly do it in the legislative branch, and where the executive cannot possibly do it, and where people along the way may have predilections, so that when you get to a courtroom and you have judicial review against a legislative standard and public policy, you have the very best kinds of review. So I would hope that that one change would be made. With respect to the appointments clause, it could be done differently, as Senator Boren has pointed out, but I do not believe the Justice Department concern is well-founded. In terms of constitutional authority, we have special counsel appointed by the Judicial Tribunal, and I think that adds another layer of insulation. The subpoena power, where there's a concern, I think it's very sound to have the board have the subpoena power. But however it is structured, colleagues, I hope we will move with dispatch on the subject. It has languished too long. And the essence of our democracy is openness, and we ought to be about it and put these facts on the table and try in a comprehensive way to work through with the FBI and the CIA and the other executive branch officials, taking into consideration their objections, but really with a very, very heavy presumption of full disclosure. Thank you.
Thank you very much. Our next witness who introduced this bill over in the House comes with particular qualifications to deal with this matter. Congressman Lou Stokes was chairman of the House Select Committee on Assassinations, which met for over a year, 1976 to December of 1977, and published some 12 volumes of testimony, documents, and exhibits. And that information, all of the information, is not, however, scheduled for release until, as I understand it, the year 2029. And so he comes with a long background and history of looking into this, and so his testimony is particularly welcome here this morning. Congressman Stokes.
Thank you very much, Mr. Chairman. Mr. Chairman, I ask that my statement be placed in the record in its entirety, and that I may just summarize. Mr. Chairman and members of the committee, I thank you for this opportunity to testify in support of Senate Joint Resolution 282, the Assassination Materials Disclosure Act of 1992. As the former chairman of the House Select Committee on Assassinations, I'm proud to sponsor this legislation, along with the distinguished chairman of the Senate Intelligence Committee, Senator David Boren, and also Senator Arlen Specter, providing for the expeditious release of materials in the possession of the government relevant to the assassination of President John F. Kennedy. This resolution was introduced because of the renewed public interest and concern over the records pertaining to the assassination of President John F. Kennedy. The House committee, which I chaired, in the course of its investigation, had at one time or the other in its possession approximately 370 cubic feet of files. Among the materials contained in these files were classified and unclassified materials on loan from federal agencies, materials generated by committee staff, materials on loan from private individuals, transcripts of committee open session hearings and meetings, and executive session hearings and meetings. There's been considerable debate about these records, including accusations that these records, if released, would contain evidence of a government cover-up or complicity of government agencies in the assassination of President Kennedy. I can assure you, Mr. Chairman and members of the committee, that nothing could be further from the truth. No member of the committee, nor member of the staff participated in any cover-up of the truth. Mr. Chairman, I'm committed to the principle that Americans are entitled to know the truth about the assassination of President Kennedy, and feel that Congress should do its best to allay fears of the American people in this regard. The American public deserves to know the factual truth about this important event in our nation's history. In preparing this joint resolution, I was in contact with President Ford, former President Ford, other former members of the Warren Commission. I've consulted with congressional committees and noted constitutional scholars. I've also formally and informally contacted other relevant and interested parties inside and outside of the government. You should know that the National Archives not only assisted in the drafting of our resolution, but they took the time to review with us the assassination documents now in their possession. In the case of the CIA, the FBI, and the Secret Service, each of their directors have cooperated in the drafting of this measure, and each of them has pledged the full cooperation of their respective agencies in the expeditious release of all assassination materials. S.J. Res. 282 mandates that all federal records pertaining to the assassination be reviewed for release, including records from the CIA, the FBI, the Warren Commission, the House Select Committee on Assassinations, and the Church Committee. The resolution establishes an impartial, independent 5-member review board with overall responsibility for reviewing and opening files. The board will be appointed by the special federal court, which appoints independent counsels, and is required to complete its work within 2 years of its first meeting. S.J. Res. 282 requires a strong presumption in favor of disclosure. All records will be released unless there is clear and convincing evidence that postponing release is essential to a vital interest. There's a balancing process established by the joint resolution for applying disclosure standards weighed against the strong public interest in disclosure. To address the concerns of the executive branch relative to disclosure, specific standards were established relative to records in its possession. The resolution provides that in the event that the President determines that certain records qualify for postponement of disclosure, the President must submit a written statement to congressional committees setting forth the reason or reasons for superseding the board's determinations for disclosure and a complete copy of the material at issue. Moreover, notice shall be published in the Federal Register including a description of the size and nature of the assassination material concerned and the grounds for postponement. Mr. Chairman, since the introduction of this resolution, there have been official and unofficial views shared in this proposal. The one with which most of us are concerned with is that of the Department of Justice. In my opinion, there is one major misunderstanding held by the department that, once clarified, would take care of other concerns that are being expressed. This issue involves that of the independently appointed review board. As you know, the Justice Department takes the position that since the review board has powers to review executive branch material and to authorize release of these materials, it would have to be considered an executive agency. This is not the premise of S.J. Res. 282. This legislation presupposes that the board is an independent agency, not an executive branch agency, and therefore is not under the control of the executive branch or control of the President. Remember, our intent is to establish a neutral body that gives legitimacy to our efforts. The very structure and appointment of the board is designed to accomplish this by dispelling any notion of prejudice by any political persuasions or improprieties of any manner. Thus, it is imperative that the review board be an independent agency. There are other concerns expressed by the Justice Department that I think can be settled with some debate and dialogue between the parties. My staff and I have already begun to draft some suggestions in response to these issues and would be happy to share them with this committee. Mr. Chairman, I recognize that there are some differences about process regarding release of the files. But we must remember that the American people have asked for our leadership on this issue, that we must do what we can as expeditiously as we can to comply with their request. I believe this resolution addresses this need. I'm ready to work with you and this committee in whatever way I can to expedite action on this resolution. I'd be pleased to answer any questions.
Thank you very much, all of you. We'll go on, since we have several members here, we'll go by a 6-minute rule here so everyone gets a chance to get questions in early in the process. We keep hearing rumors that there may be an executive order in the works over at the White House to release the executive branch records as it chooses, which would, I guess, maybe have some impact on looking as though it was preempting this proposed legislation. If that occurred, do you feel, Mr. Stokes, that this would that the legislation is still necessary?
I think, Mr. Chairman, that the President, of course, could release such executive records as he would like. They're under his jurisdiction. No. However, I'm not sure that that would take care of the records here on the House side and the Senate side of the committees that have jurisdiction. Also, it does not address that part of our resolution which gives authority to the review board working through the Attorney General's office to obtain copies of court records that are under seal, grand jury proceedings that are under seal, all of which are provided for in our resolution by action through the Attorney General's office.
Thank you. Senator Specter, you feel the same way?
Well, not quite, but I do not think that an executive order would in any way eliminate the need for this legislation.
Okay.
This legislation is much more comprehensive, and if there is an executive order, that's okay, but let's get on with our job here.
Senator Bourne, same.
I would agree with what my colleagues have said. In addition, we want to assure the impartiality of the process, and I think by having the executive branch itself be a judge and jury over the process of releasing documents in its custody at its own discretion, making decisions about which documents should be released would not be the kind of process that would have the objectivity that would reassure the American people, and that is one of the principal reasons for this legislation. So I think we'd still need the legislation.
Yeah. Mr. Stokes, how much of the material that you have over there would be still entangled with third agency material, which agencies will still have to review before release? Would that be the bulk of your material, or would that be a small part?
I would say a great deal of it, Mr. Chairman, would be entailed as agency material, both classified and unclassified materials from those agencies.
What's the status of the material you have? Is most of it readily releasable now? Is it necessary to wait for this bill to release some of that? What are the rules on that over at the House?
This resolution and legislation would be required, Mr. Chairman, because we're currently holding in those files information related to personnel records, that is administrative records. There's classified material there which we did not have the authority to release. We had a unilateral agreement with each agency, but we had no authority to unilaterally release any classified documents. So there's a great deal of classified material there. There are the autopsy records, and our resolution speaks to the autopsy records. There are confidential records there, which come under the category where persons are still living, where there could be invasions of privacy.
How much of the material is at the archives now, and how much is at the retained at the House?
All of it is in the archives. We put all of our materials there.
Okay,
we did not retain
but the
any
release
of it.
of that, even though it's over at archives, the release of that is still governed by your own rules in the House. Is that correct?
It was placed under seal, Mr. Chairman, for a period of 50 years.
Yeah. Senator Bourne, the Select Committee on Intelligence has custody of the records of the Church Committee and certain records of the Rockefeller Commission. How well organized are these files? Have they been gone through, and are they ready to be released? What's the volume? Could you tell us a little bit about those files?
Mr. Chairman, we have all of those files are in a single room over in the archives. There are about 500 boxes contained in these files. I'm told that the vast majority of them don't directly relate to the assassination, but probably 5,000 documents do. Of these, some are classified and some are unclassified. Some relate to intelligence sources and methods. Some also would have privacy concerns. So while I think that ultimately they're probably all releasable, there would have to be some review under the process established before they could be released. The index is very rudimentary as we've gone back and looked at it. Our staff is already beginning to sift through and trying to separate out these materials. So our hope is that we will have the Kennedy material more or less segregated from the rest of the files so that we'll be ready to be up and going when the decision on government-wide release is made.
How much of this would be releasable as you see it immediately, and how much of it involves third-party agencies that would have to also sign off on this?
Well, a good bit involves third-party agencies, but copies from third-party agencies. But I would say the majority of it would be releasable very, very quickly, I think. And as I say, ultimately, I think virtually all of it would be releasable under the procedures in this resolution.
How long do you anticipate it'll take to complete this review by the Senate Select Committee?
Well, I think that again, once the decision is made, the review process, we're talking here in terms of more than a week or two. We're talking in terms of multiple weeks or a few months in order to complete the process with regard to all the information at our disposal.
Yeah. Do you recall, we had a policy at one time of release of information, and that was reversed under President Reagan. Do you recall what the circumstances were of that, or do you know why that was reversed?
Mr. Chairman, I don't. Maybe some of my colleagues do, but because occasionally from time to time we have had requests for the release of information in the past, and our committee staff has worked with the CIA, and in several cases the release has been accommodated. I don't know what the circumstances were.
Congressman Stokes, do you know what that was? Do you recall that?
I do not recall that, Mr. Chairman. I'm not aware of any release of anything that was sealed by the House Select Committee.
Well, this would be prior to that. This was back, President Kennedy had initiated, ironically, President Kennedy's the one who had initiated a policy of release of information, that reviewing that and having it released, and that policy was reversed, as I understand it, when President Reagan came in. It was reversed in 1981. And I didn't recall the circumstances of that. I thought since you'd been involved with this, you might recall that.
Are these historical documents not related to the assassination, but other historical documents?
That's correct. There was a general policy of earlier release than had been done previously, and that's the policy. It was reversed. I don't know why it was.
Mr. Chairman, let me say that's been changed. Certainly, again, Mr. Gates, I think, will be before you later, but he has announced a major change of policy in this direction toward speeding the release of historical documents, which I'm sure he can describe.
Up on the first round, Senator Roth.
It seems to me that there's a clear consensus, Mr. Chairman, as to the need for disclosure. But I think subsidiary to that are two basic questions. One is, what is relevant, and how can we most expeditiously release the maximum amount of material? And on the question of relevance, Senator Boren, you made mention of relations with Castro, Cuba. There are all kinds of rumors floating around, organized crime, so forth. Are those relevant under your legislation, or should they be? Is that a decision that should be made by the Congress or by the committee that's established?
Senator Roth, I think probably the best way to make some of those decisions would be under policies by the committee. That's established, the review board or whatever process is established. We set it up as a review panel. Some of these can be made by the executive director. For example, if the agency under the procedures of this resolution has some doubt as to whether or not it should be released, this is discussed informally with the executive director of the review board. The two of them agree that it is relevant, then it'll be released. If there's a question, it's referred to the review board. I would think that if we err, we should err on the side of including too much in terms of what is released, rather than erring on the side of including too little. And since, for example, there have been accusations that the position that the late president took on issues of Cuban policy, or the potential involvement of organized crime, actions he took against organized crime, for example. There are various individuals and groups that might have been motivated to have participated in the assassination. I think if we would rule out consideration of those matters as not directly relevant, because the file in question might not mention, let's say, the late president by name, or it might not relate to where someone was on the date of the assassination, something very specific, I think we would rule out too much. So it may well be that the review board itself may ultimately have to set the parameters, but I think it would be important that at least report language be adopted by this committee that I would hope would urge that if there's a doubt, resolve that doubt in favor of inclusiveness.
Well, I agree we should err on the side of more than little as a general rule. The whole purpose of this program, of course, is to release. And if we leave too much discretion to the committee, will we be accomplishing the purpose of the legislation, or should Congress really try to define with some clarity what needs to be done? Senator Specter or Congressman Stokes, do you have any feeling on that?
Senator Roth, I think Congress is saying through this legislation, we want everything released unless there is some salient, vital reason for not releasing it. And I think that's the approach we need to adhere to. Therefore, we specify in the legislation that even where something is postponed, there's a continuous process towards the end of trying to eventually release it and not retain it in our files. And so I think that's the best way for us to try and go through this process.
Well, let me go back to the comment made by Senator Boren
Sure.
about organized crime and our relations with Cuba. Would that be within the boundaries of this proposal?
Only to the extent, I think, that where the privacy law would apply as it relates to living persons. I think there may be some ramifications within those two areas that you've mentioned, that is organized crime and relations with Cuba. But basically, I think most of that ought to be released. I think it's going to be important for people. For instance, in our files are a number of intercepts, telephone intercepts, members of organized crime, making references to Bobby Kennedy and Jack Kennedy, making references to the necessity for them to be killed. I think it's important, if we're going to release everything, that those tapes be put into public domain so that the American people have a chance to analyze that type of data also.
Let me just add one further question, then turn to you, Mr. Spector. But, Mr. Stokes, you brought the question of privacy. Now, basically, what we're doing is investigating something that is very personal. We're investigating the assassination of the president that affects the first family, the Kennedy family. I'm not quite certain how you construe this invasion of privacy, because it seems to me it goes right to the heart of what we're seeking to disclose. How do you reconcile this desire to protect those that deserve protection, and yet at the same time we would be asking a committee to disclose as much as possible to lay to rest the question? How do you reconcile those two goals?
Well, I think that Congressman Stokes and I have discussed some of this in the past. If there was some specific commitment made on privacy to an individual who came forward, that would be a factor. But even then, with the passage of time and people are no longer alive and there's no reputation issue, that would have to be considered.
Would that be the case of the X-rays and pictures of death? Wasn't there some kind of agreement there?
That is a very unusual situation, Senator Roth. The wishes of the Kennedy family prevailed in not having those available even to the commissioners or to the staff. And I've already said that I thought that we should have had access to that in line with what we had to make factual determinations, and it would not have gotten into the public domain. They have since been reviewed. They were reviewed a long time ago. In 1971, I believe it was, there was an independent group of forensic pathologists, 8 in number, who reviewed the X-rays and photographs, and 7 confirmed the conclusions of the commission.
But they haven't been released publicly.
Well, I think some of them may have been published by the House committee in its work, so that they have been released as of this time. But I think that there is still a deed of gift which is subject to the control of the Kennedy family. And I think that particular aspect of privacy can be accommodated, considering the wishes of the Kennedy family, and still have appropriate access to forensic pathologists and scholars and journalists and serious students. I think that can be done. When you raise a question about what do you do as to organized crime or about relations with Cuba, I believe that the presumption ought to be on release where there is some realistic or reasonable connection. And I think that would go in a time frame. You're not going to release foreign relations with Cuba from 1975 that don't have anything to do with the assassination. And if you have some specific name organized crime figures, certainly, as Congressman Stokes pointed out, if President Kennedy or Attorney General Kennedy either is mentioned, then you're going to have a disclosure of that beyond any question. But I do not think that the Congress can put any firm parameter except to say what is relevant, with the emphasis being on liberality in interpretation. If there's a mention, of course, if it's within the time frame, if it might lead to a motivation to assassinate the president, either by organized crime figures or by Castro or someone else, let's move to have it disclosed. Certainly when you're dealing with 1962, 1, 3, 4, 1963 and before, it's such a remote time period that there ought to be very little weight to concealment.
My time is up. In the area of organized crime also, there are some confidentiality agreements that we entered into in order to be able to get certain testimony. We would think that those confidential agreements made with those persons who are still living and who would be subject to danger ought to be observed.
Time is up. Unless those could be, unless agreements could be gotten to release those now.
That is correct, Senator Levin.
Thank you, Mr. Chairman. Our committee counsel has given me a very ballpark estimate of the materials that have and haven't been released. And just tell me if this sounds about right. If not, maybe you can give us a ballpark estimate, not so much in terms of boxes and cubic feet, although that's probably the most precise way to measure, but in terms of documents. His estimate is that if there's perhaps 1 million documents relating to the assassination, depending upon how you might define the words relating to the assassination, that there's probably been as many documents that have not been released as have been released. Is that an estimate you would concur in, Senator Bourne, or?
I think so. Chairman Stokes may even be more familiar, but I would say that's certainly within the bounds, I would think.
I think that's in the ballpark, Senator Levin.
Okay. Senator Bourne, on the question of appointment of the review board, you indicated a couple alternatives.
Yes.
The first alternative that you mentioned was that the president and the leadership of the Congress might each appoint some members of that review board, and then you said that that would be perhaps subject to constitutional question.
I think again you've had the same question raised by a judicial appointment. The Justice Department is arguing that this is an executive branch agency, although, as Chairman Stokes has said, I don't think the unique circumstances we're dealing with here should cause it to be viewed as an executive branch agency. I think that's, the Justice Department always worries about setting precedents for unforeseen situations in the future, and I think they're seeing some ghosts here that are not really there. So I don't think this is an executive branch agency. I don't think it should be viewed that way. And but I think this, again, is the kind of complaint that could be raised. I might say that I think the Morrison case, the case of Morrison versus Olson, which says that the judiciary can make appointments if the appointing process would not be incongruous to the rest of the work that the court does, I think would uphold the method that we have of appointment in this resolution. But of course, there are arguments that would be raised about it.
Do you think that the Justice Department would object on constitutional grounds to your first alternative?
I don't know. My hope would be that, again, since it's a special circumstance, since the agencies involved for the most part have all been very cooperative, want to see this information released, it's my hope that for once the Justice Department could set theology aside and try to deal with the facts as they are and with this situation. Be cooperative.
Do any of you know of an instance where a non-judicial officer has been appointed by a court?
Well, I don't know if you want to call this non-judicial exactly. It's of course we've had special counsels appointed. I suppose you would say that they have some judicial authority. Again, we're talking about a panel which is to conduct a review process, which is, in a sense, quasi-judicial, since they will be making decisions about release that can be overturned only by the president himself. So I would argue that this would have something of that kind of function and not be something that would be strictly incongruous to judicial activity.
Let me ask each of you, if you know, what the closest analogy would be to this review board that is currently appointed by a court. Is the independent counsel the closest analogy that exists? If any of you know, it's fine if you don't have it at your fingertips, but if you do want to offer that?
I think that's the basic concept that we adhere to in terms of trying to ascertain the best means to be able to put together a review board with an executive director where they would all be independent individuals, sort of following the independent concept related to special counsel.
Senator Levin, I might mention that there have been instances where, for example, supervisors of elections, voting rights commissioners, and others performing these kinds of functions have also been appointed by courts. So they certainly have some relationship, often depending on litigation, but they're really being given other kinds of responsibilities.
I believe that the special counsel, independent counsel analogy is dispositive on the legal issue. The Justice Department is an executive branch. Special counsel would fall, independent counsel would fall in the executive branch. But the Attorney General is quasi-judicial. Prosecuting attorney is part judge and part advocate, has judicial qualities as well as executive qualities. This review board would function really in a couple of ways. They would make judgments as to what ought to be released, so to that extent they would be judicial. But they would certainly have an advocacy role to take the initiative on themselves. They are not waiting for somebody to come forward as a lawyer and tell them what to do in an advocacy sense. They have that role as well. So I think it's a pretty close legal parallel.
Senator Specter, you made reference to the fact that the members of the commission, the Warren Commission, were not allowed to see the photographs and the x-rays, I believe you said, or didn't see. Could you just tell us what the background of that was? It was a surprise to me when you said it too. And
well, it is something which ought to be known, but the Chief Justice may have seen them privately. I have reason to believe he did see them privately, but that was my area of responsibility, and I pressed to see them, as did other members of the staff.
No, I mean the commission. You said the members of the commission did not see x-rays or autopsy photographs.
Well, they did not, to the best of my knowledge.
Why were they not permitted to see the photographs?
They were not permitted to see them because there was a sense that they might come into the public domain, and it was thought that undesirable to have the vibrant, handsome young president in a state of disfigurement, that they would not be kept confidential. That is the only reason which was given to me. I discussed the matter at length with the general counsel, who was J. Lee Rankin, and the other lawyers who worked on the commission had a similar view, but I had the central responsibility, and I know that I wrote a memorandum back in 1964 on the subject, and I pressed on it on quite a number of occasions.
Thank you.
Senator Levin, I might add that the autopsy material was given at the time by the government to the Kennedy family. The Kennedy family then transferred it to the archives under a deed of trust with a trustee established. And in the intervening period of time described by, since the events described by Senator Specter, the trustee has responded to requests and has granted, I believe, about 20 requests for a thorough review by experts, scientists, pathologists, and others of the materials. Obviously, the sensitivity is still that you would not want inappropriate photographs, published and disseminated to the public, even though there's a willingness by the trustee, as has been indicated by the family and the trustee in the past, to have appropriate authorities thoroughly look at them now.
Public, I was curious about the refusal or the inability of the Warren Commission to see those photographs, and I would, in closing, just join the three of you in hoping that the Justice Department would reconsider its position on this bill, because if over half or about half of the documents, and maybe we're talking of 1 million documents, have not been released, I find that there's any public purpose that could possibly justify the refusal to release less than a handful of documents, or more than a handful of documents to the public. And to think that there may be 500,000 documents out there that have not been released, to me, is absolutely unacceptable, and I do hope the Justice Department will take a much more positive attitude towards this legislation.
Senator Levin, the photos and the x-rays, just one first of the sentence, Mr. Chairman, was the subject of very intense public scrutiny in 1965 and 6 when Edwin Epstein's book Inquest came out and other books were written, and that led to the review by the 8-member board of independent forensic pathologists who confirmed the Warren Commission conclusions.
Senator Lieberman.
Thank you, Mr. Chairman. I thank my colleagues for their leadership in this matter, and particularly for the strong support that they've given to disclosure of the materials that are still in the government's files related to the Kennedy assassination. What I'd like to do now is to go over some of the exceptions to disclosure that are listed in Section 6 of this bill, because I'm concerned that any time we create exceptions in law, it obviously opens a possibility that those who implement those exceptions will go well beyond the clear statements that you've made this morning that create not only a presumption in the normal legal sense in which we mean that for disclosure, but a personal desire, as I hear you, that just about everything be disclosed for the reasons that we've stated amply. In Section 6, you list 4 different reasons, grounds for postponement of disclosure. I do want to say that in 3 of them, you, on the face of it, set up a balancing test. For instance, in the first category, you say that these are reasons not to disclose, but only if the threat posed by the disclosure is of such gravity that it outweighs any public interest in its disclosure. But allowing for that incident, the only one in which you don't have such a balance is the third, where you say that release can be postponed if it would constitute a substantial and unjustified violation of an understanding of confidentiality between a government agent and a witness or a foreign government. Let me begin with the first and ask you to just talk a little bit about what you had in mind so that perhaps we can create a record here in favor of disclosure, or we may come to the conclusion that some of these are too broad. For instance, first you say that disclosure should be postponed if information release would reveal an intelligence agent, B, an intelligence source or method which is currently utilized or reasonably expected to be utilized, and C, any other matter currently relating to the military defense, intelligence operations, or conduct of foreign relations of the United States. Let me ask you, if you would, to talk a little bit on the record about what you have in mind there, and I suppose I'd pose this challenging question, which is, can there be anything that was being utilized 30 years ago that really still does relate to the national security of the United States?
Well, Senator Lieberman, in theory, there could be. As I said in my opening statement, I think there'll be very, very few, if any, instances of this at all. But there could be a situation that I haven't envisioned where it could come up. You could have the identity of an agent undercover who might still be an agent undercover, even this many years later. I think that's unlikely, but it's possible. There could be some very sensitive technical collection method or some method of collecting raw intelligence data that was used then that is still being used that might be generally unknown to others outside the intelligence community. I think this is also very unlikely, but it's the kind of thing that we've always been sensitive to try to protect sources and methods which are still very useful to our government in terms of obtaining information that would be compromised. We have all sorts of various ways that, however, that the information can still be disclosed. Let's suppose that the only thing that is sensitive is the name of, let's hypothesize for a moment that there still is an agent, an undercover agent, a very valuable one. Maybe he or she is now someplace else in the world, stationed overseas, obtaining very, very important information for this country. And if it were released now that that person happened to be, let us say, a CIA agent, their life would be jeopardized, the information flow would stop. It could very well be that this could be released by saying a person, an agent of the Central Intelligence Agency, may perhaps described in some way, issued a report on such and such a date or obtained this information. In other words, that virtually all the information in the document or in the communications intercept or whatever it happened to be could still be released absent only the name. And even the person, the kind of person that we're talking about could be described, a certain kind of agent in the intelligence community, so that the public would have the essential information and still the name could be spared. So even if you fell under one of these categories, and I think it would be extremely rare, and I can't even think of an example right now, I can't imagine one, but just in case that happened, we still would have ways of releasing all of the essential information. And when we talk about redacting, some of us have seen information sometimes under the Freedom of Information Act where everything is lined out except the ands and these and buts and fors, and obviously you get no information when that happens. We're not talking about that kind of redaction. We're talking about having very few words removed, and when that is done, to have perhaps a summary inserted so that the document will make sense and the essence of it will be preserved.
Well, accepting your premise, which you've stated strongly and eloquently, that these exceptions would be extremely unlikely, is it still worth creating these exceptions? Is there any danger that they would be misused or used as a basis for contesting the release of information that would otherwise be released?
Senator Lieberman, my colleagues will probably want to comment on this as well. I think we would, in order to be responsible, have to set up certain categories that require careful scrutiny and balancing. I think for us to simply take 1 million documents, as has been possibly estimated here, and sort of unload them like you would a freight car on a dock and say, here they are, everyone come and look, without any consideration of the possibility that buried like a needle in the haystack, there might be that one case where a life would be endangered, some vital national security interest would be disclosed, or a few cases, or situations where privacy would be unnecessarily invaded when there's a way to still release the information but be sensitive to privacy concerns, still maintain all our objectives. I don't believe we would be responsible, but what we've tried to do is set up a system with the strongest possible presumption for release, and one that would allow for that determination as quickly as possible.
Thank you. My time is up, Mr. Chairman.
Thank you, Mr. Chairman. I may not have an opportunity to hear Professor Ernest May testify, so I want to at least raise some of the issues that he has. I first met Professor May back in 1972 when I was selected along with Barbara Jordan, Yvonne Braithwaite Burke, and a young man named Alan Steelman to attend the John F. Kennedy Institute of Politics at Harvard. They were running a Head Start program for disadvantaged minorities at that time to try to instruct young congressmen what they might expect when they went to Washington. But Professor May has raised an interesting and I think a very wise note of caution. He suggests that if we release everything today, all 1 million documents that Senator Levin, Senator Boren, and others are talking about, if you release everything, it may take 10 years for this particular review board to sort through it. And depending upon where you are on the life expectancy spectrum at that time, many of us will not be here to witness that arrival at truth should it come. Secondly, he suggests that even if you release every bit of information that is currently available, that doubts will never be removed about the Kennedy assassination. There will always be conspiracists. There were people who, as he points out, that believe that now Churchill somehow was involved in a conspiracy to bring about Pearl Harbor in order to get the United States injected into World War II. So that's assuming you release every bit of information. Legislation will never remove the doubts. Novelists and polemicists will always either be writing novels or making films in order to spin conspiracy theories. But then he raises, I think, a point that those of us who supported this legislation, introduced it, have to give some strong consideration to. He said every bit of information is not going to be released. It will not be released. And those of us who went through the John Tower experience know, for example, the insidious aspect of releasing raw FBI files. Information that comes in over the transom or through a sewer that is not corroborated, not tested, but simply ends up in a file and could in fact pose some very damaging information, which is completely untrue. A review board would have to take that into account as to whether or not that kind of information ought to be released, and they may come down and say it shouldn't be. There are other issues. Documents may be lost, they may be destroyed. We may decide, or the review board may decide, that tax returns should not be released because of their confidentiality. So he suggests, and I agree, that everything is not going to be released for a variety of reasons. But now he poses the important question for all of us. If the board yields to pressure to release everything, no exceptions, no privacy, no national security, no anything, then the board will, in fact, start out and continue on a very large and perhaps unending fishing expedition. And then he says if the board resists the pressure, it's going to be accused of being engaged in a whitewash. So it's a lose-lose proposition for this review board. And so what Professor May has suggested, and he will correct me if I'm oversimplifying what he has to suggest, that what we ought to do is to start with a proposition that everything ought to be released. That is the goal of releasing information within the committees, congressional committees, executive agencies, various commissions. Everything should be released, and then put the burden upon the individual agencies or committees or commissions or the president to say why it shouldn't be released, and that the board itself should be in the business of trying to determine whether uniform guidelines ought to be established so that we know whether the CIA has adopted the same guidelines as the FBI and whether they can justify those guidelines in terms of not releasing information. And then if the review board disagrees with that, it could go back to the agency or back to the commission or back to the president and say, Mr. President or Director, we think that this is a really inappropriate exercise of restraint here. We think this information should come forward. And then if it doesn't produce that kind of release of information, at least at that particular point, to prepare a record that would seek to validate the record holder's non-disclosure. But I think he raises a point that those of us who support legislation have to give strong consideration to as to whether or not we are putting this review board, however it's constituted and however it's appointed, as to whether putting it in a possible situation which will only, after 10 years or 20 years of investigation, bring us no closer to the truth, but lead to another claim of whitewash or fishing expedition. I'd like each of you to comment on that. Congressman Stokes.
Thank you, Senator Cohen. Firstly, let me say that Senator Specter, Senator Boren, and along with our staffs, all of us had a great deal of discussion as we drafted this resolution in terms of how long such a review board should be in existence. And we kept coming back to the fact that we needed to try to have an orderly process by which we could get as much of this information out to the American public as quickly as we could. There was even proposed at one time about a 5-year review board, and we said, no, the American people are going to say that here again is another act of procrastination, and they just don't want to get this stuff out. So we finally decided upon a 2-year review board with the understanding that they could extend themselves for 1 additional year. Our thinking was that everything should be gotten out within that 2-year period and as early as possible. However, no one can tell what's going to really occur until once we've undergone the process. But I think it's important that we try to do it as expeditiously as possible, but you cannot just dump million documents out here and encounter the type of lawsuits, invasions of privacy, all those type of things.
Well, if I could interrupt, Congressman Stokes, you and I also had the privilege of serving on the Iran-Contra Committee, and the first charge, of course, that we found is by setting a deadline that we thereby were contributing to the delay in the releasing of the information by imposing restrictions such as that we were never going to really fully get at the truth, because the moment you start looking at documents, those documents will lead you down another direction or to an additional level of documentation you might seek, so there's no end to it. I think the 2-year time frame or 3-year time frame is probably not going to be sufficient, but maybe I could just have Senator Specter and Boren just respond on Professor May's proposal.
Senator Cohen, I think it is true that no matter what is done, there are still going to be some doubts at the end. They're still writing about the conspiracy on the assassination of President Lincoln, which is a century before the assassination of President Kennedy. But I believe that this approach goes very far and gives very, very great latitude for disclosure. It is a best efforts plus on the part of the government to make all this information available. When you have a more generalized standard about having the review board disclose it, unless some agency comes in and cites some good reason, it may work out to be very much that way as a matter of practice. We have articulated some exceptions, and as Senator Lieberman points out, what is there going to be today on an identity of an agent? Well, there may be some around, and if so, they ought to be. We ought to have a concern for them. You have a private arrangement that somebody comes forward to give information, that ought to be honored, if at all possible. There may be some circumstances where you cannot honor a private commitment. The law sometimes overrides private agreements, and even agreements with foreign governments, if there's a dominant public policy concern. But to the extent they can be accommodated, you try to do so. But I believe that this approach is a very, very good approach. It's not a perfect approach, but in the face of this kind of maximum disclosure, really full disclosure, having faced a lot of questions about this subject over a lot of years, I think it'll give a lot of people a sense that we're really trying to do our very, very best.
Senator Cohen, I think that I certainly agree with the validity of the points that Professor May has raised. I think that the way that we think the board will function is pretty much along the lines that he hopes it will function in terms of your summary. We would not refer all matters to the board. In fact, the presumption would be everything ought to be released. And as long as agencies are releasing, they would merely pass their decisions by the executive director. If the executive director and not to the full board, if the executive director and the agency agree this file ought to be released, it's released. The board doesn't even have to look at it. So we don't slow down the process. It would be my thought that 95%, maybe 99% of the material will simply be released by the agencies under guidelines that they've established, accepted by the executive director, and released. It will only be those few cases where they're very difficult policy questions or individual fact questions that the review board would even look at it. And then the decision of the review board is final unless the president overturns it. So we're trying to streamline the process. And I think you're absolutely right. If Professor May or other witnesses today can suggest ways we can further streamline it, it would be very, very valuable. It's worth the effort, even if the process is imperfect. I'm convinced that the more of these documents that are released, not only on this matter, but other matters as well, as Mr. Gates has said, of historic importance, the more we really assure accountability, and the more we assure that people that are working on the secret areas of government, intelligence community and others today, when they know that someday, in the not too distant future, their actions are going to be known, documents will be released. This causes, I think, all of us to be more careful, more accountable to the values that we believe in this country. So I think it's a healthy process, even though it's bound to be imperfect.
Thank you very much. We'll have a very, very abbreviated second round here. I just want to make one point of clarification here. Senator Specter, I think it's correct that the Kennedy family did not prevent the Warren Commission from seeing the autopsy photos or other materials. That was turned over later for their control. Is that correct?
Well, I did not say anything about the Kennedy family.
No, I just wanted to clarify that because it could be implied, I think, from what was said earlier about the Warren Commission not looking, or not everybody not seeing the autopsy photos, that perhaps that was held up or not permitted by the wishes of the Kennedy family, and I don't believe that's correct, is it?
Well, Mr. Chairman, I think the Kennedy family did have a feeling on the subject. I cannot testify to that from my own personal knowledge. As an assistant counsel, there was the concern expressed, which I have already articulated, as to having a public disclosure of the disfigurement, and the commission had the authority to make the judgments. There was no question about that. It was a commission decision. The Kennedy family did not decide the issue. I believe the commission did.
Just one other question, that is, has anybody made an estimate on the cost that this would entail? You didn't make an estimate in the bill itself or in the accompanying material, and I think we're getting into something here where we've got to consider the cost of it also. The previous commissions that went into full investigation and so on, they were not inexpensive. I think the Warren Commission was $10 million, I believe, and so that's something we have to consider. Did anyone have an estimate of the cost of this? Mr. Stokes?
We have not had the House bill costed yet, Mr. Chairman.
We made a request to CBO. We don't have an answer back yet from them. They're working on it. So,
Mr. Chairman, the Warren Commission was very inexpensive. The assistant counsel were paid $75 a day.
Mr. Chairman, let me raise the Kennedy family just a moment ago, and I have consulted with some members of the family, mainly through Senator Kennedy, who indicated that in terms of this legislation and the presumption of the release of information, that they're supportive of the release of information and the files as a matter of public policy. And they're confident that the deed of trust arrangement already established on some of those items, that there's a question of propriety as to what would appear in the public in terms of photographic detail. These matters can be worked out. So we've had a very good consultation and a very constructive consultation through Senator Kennedy with the members of the Kennedy family, which is much appreciated.
it's my understanding that the Kennedy family was never given this material until 1966, which would be well after the Warren Commission, that they then deeded it to the National Archives. I believe that's the situation. Thank you. Senator Roth.
Thank you, Mr. Chairman. I'll be brief, too. Is there any way of building on the FOIA rules so that we don't have to set up a new and unfamiliar set of rules? In other words, to expedite the matter, can we somehow build on what we have already? Perhaps limiting review to that which has not been disclosed.
Well, I'm concerned, Mr. Chairman, if we would have a lot of this information already out if the FOI rules operated in this kind of circumstance. Since under the Freedom of Information Act, classified material in general is fairly much withheld and redacted, I think we wouldn't make much progress along this line if we were simply to try to expand on the Freedom of Information
Could I
Act.
ask you this, Senator Bourne? Are you saying that our Freedom of Information rules are inadequate generally, or are you saying they're inadequate in this kind of situation?
Well, I think that they're inadequate in this kind of situation, and I think they may well also be inadequate generally. I think that's something, again, we're in such a different environment now with the changes in the world and the changes of the Cold War environment. There may well be some reason to review the Freedom of Information Act in general in terms of greater openness and accountability, just as we are now internally reviewing intelligence files of historic importance as a matter of policy and a matter of trying to be more open and accountable. I'm not enough of an expert to give you an answer on that, but I don't think, and our staff has looked at it in great detail as to whether or not they thought the Freedom of Information Act would be an adequate vehicle to really meet our objective here, and their answer was no. They simply felt that those procedures would still leave a lot of these documents unreleased that should be released.
What kind of a staff do you anticipate your proposal creating? How large?
I haven't set up a structure, and I think part of it will depend upon exactly the size of the review panel and the process established by this committee after you've looked at the legislation, any amendments you might adopt. But I would hope it would not be large, and I would hope that most of the work could be done in-house by the agencies involved. The review board, as I said, will only come into play in those very few exceptional cases where there are questions raised, where there has to be a very careful balancing in an individual case. The rest of the review will be made by the individual agencies concerned for the most part, just spot checking with the executive director. So I wouldn't think there would have to be a whole new separate bureaucracy developed. For example, and others here, Director Sessions and Director Gates may be able to give some indication. They already have a large number of people tasked for this kind of process of review of documents already. I know there's been some addition to that already in the intelligence community in terms of numbers. I would think that the agencies would be able to do much of this in-house, and we would not establish, we're talking about numbers in the scores, not numbers in the hundreds, certainly, when we're talking about the staff of this special group. I would think a very, very small core staff would be able to handle it.
Mr. Stokes.
There's also a provision under our legislation for the review board to acquire loaned employees from our other agencies. And so that would cut down substantially on staff costs.
Thank you, Mr. Chairman.
Senator Sasser, do you have a Senator? You want to go ahead with Carl first? Yeah, Senator Levin, go ahead. We're just on that.
Whoever's next, Mr. Chairman. I don't want to usurp anybody's privilege here. Am I next or Senator Levin?
No, we'll work you in. You didn't have an initial round, so go ahead whenever you want to work in. That's all right.
Well, just a couple of very brief questions. Senator Specter, looking back on your work with the Warren Commission and knowing what you know now, how extensive was the withholding of documents by various government agencies? Was this a problem for the Warren Commission as you envision it, or as you recall it in your days as service, I think, as deputy counsel for that commission?
Senator Sasser, with respect to the work which I did, which was involved with so-called Area 1, the trajectory of the bullets, the impact, the position of the president, the position of Governor Conley, everything was disclosed. There was nothing which was withheld, with the exception of the photographs and x-rays, which I had commented about earlier. With respect to the other areas, for example, his foreign travels, Oswald's foreign travels in Russia and in Mexico, and the relationship with Cuba, I think that most of that material was made available, but I could not answer the specifics. The others who work there would have to be responsive to that. But I think that there is a sufficient public concern about it so that we, at this juncture, and should have done it earlier, put it all in the public domain.
But of your own knowledge, you don't recall any problems in your specific area with agencies withholding documents. That's not to say that might not have occurred in other areas of the investigation, but in your specific area.
Senator Sasser, in my area, there was no problem. What I did was to go through the autopsy surgeons, to question them, to question the doctors at Parkland Hospital, to work on the ballistics, to work on the trajectory, and every single bit of that information was put into the public record with the exception of the photos and x-rays.
Well, thank you, Senator Specter. Let me ask my friend Senator Bourne a brief question here about how the review board is set up in the resolution. It relates to the fact that, my question relates to the fact that the executive branch has the final say in the disposition of congressional documents. Now, it seems to me that there might be some legitimate question here about separation of powers raised by the resolution. Now, I don't raise this as a technicality or really just as a matter of congressional ego. I do think that there may be some legitimate separation of powers, legitimate separation of powers issue here. And I, for one, believe very strongly in a separation of powers as set forth in the Constitution. Why not structure the board in such a way that at least some of the members are appointed by the congressional leadership? I'm sure you considered that and probably rejected it, and I'd just be interested in why.
Senator Sasser, I mentioned this earlier in my opening statement before you came in. I think one of the alternatives that we should consider, if this committee decides not to have the judiciary appoint the review panel, would be a split appointive authority between the President and the Congress, with the leadership of the Congress appointing some of the members and the President appointing others. I believe in this case, the way we have it structured, we've not violated the provision of separation of powers. We have, in essence, by passing this legislation, adopted congressional policy. We have decided on the standards under which this information that's in our custody, for example, the Church Committee files now in the custody of the Senate, the House Committee files in the custody of the House. By virtue of legislative action, we ourselves have set up a process and a standard which we have said should constitute the method of release. So I think this establishes our own right. It's interesting to me, and you undoubtedly will be hearing from the Justice Department, that they claim that all of this should be viewed as a matter of executive branch prerogative, and that only the executive branch should have the last word on the say of release of all these documents, even those documents in the custody of congressional committees. Now, I think that the real violation of separation of powers would occur if we were to accept this premise by the Justice Department that not only do they have the right to decide which documents now held by executive agencies should be released, but they even have the right, as a matter of executive privilege, to decide what documents held by our congressional committees should be released. So I think we have taken care in the way we have crafted this. There is also a paragraph in the resolution which explicitly states that nothing in this legislation should be taken as in any way giving away the authority of Congress to make these decisions about release of documents that it holds for itself. We're simply deciding on this occasion to set up this process. But if for any reason the committee should look for an alternative, I think perhaps the best alternative would be one which would split the appointive authority between the President and the congressional leadership.
And I take it that you are satisfied that propriety can be observed in the release of some of these photographs. For example, I'd be horrified at the thought of some of these autopsy photographs getting in the stream of the popular media and going through the supermarkets and seeing on the cover of the National Observer an autopsy photograph of the late President Kennedy.
Yes, sir. I would agree with you, Senator Sasser, 100%. I don't think any of us want to see that. That is certainly not necessary in order for the public and for scholars and for others to have an opportunity to have this information. These records are in the archives under a deed of trust. There's a trustee established in cooperation with the family for this matter to really set up standards of propriety in the way in which photographs, for example, autopsy photographs could be handled. And we reference that in the resolution, and we indicate that access to these and use of these particular kinds of documents like the photographs, autopsy photographs, should be under conditions approved by the trustee. The trustee has been very open and cooperative in the past in approving appropriate arrangements. I think this would be done in the future as well, but so we could have all the facts out without the horror and impropriety of having those kinds of things appear in supermarket tabloids.
Thank you.
Senator Levin, anything on second round?
Yeah, just a couple questions. One is relates to the decisions of the executive director. Is it intended that all decisions of the executive director relative to the release or the postponement of the release of documents be subject to the review by the board? Is that the intention?
No. If there's a decision in favor of release, by the executive director, and no one appeals that decision of release. In other words, if the agency, let's say it happened to be a CIA document, if the CIA does not appeal the release of that document, the president does not appeal the release of that document, then the decision of the executive director would be final, the release would go forward. And I would imagine, as I said to Senator Cohen, that would be the case 90% of the time or more, hopefully more.
So they are subject to review upon appeal?
Subject to review upon appeal.
All right. The other question relates to something which Senator Specter said, and there's now some confusion, I think, in my mind, and maybe others, on this question of the X-rays and the photographs, the autopsy photographs. In your original testimony, what you offered is that the commission, that material was not made available to the commission. And then later in response to a question, you said that, I thought you said the commission decided not to look at that material. And I'm wondering, since you raised this question, whether you can clarify it. Was this material not available to the commission, or did the commission decide not to review that material?
Senator Levin, I think it is about the same thing. I can tell you what I know. I know that as the assistant counsel working on that area, I asked to see the materials. And it might be appropriate, since there's been so much discussion on it, to put into the record the two memoranda which come out of the Congressional Committee, one dated April 30th, 1964, from me to Mr. Rankin, and one dated May 12th, exactly 28 years ago today, from me to Mr. Rankin on the subject. I asked to see the photos and X-rays, and I was told that there was a concern about having them get into the public milieu. And my response to that was the obvious one, that if the commission staff had access, they would be protected. And I know that I did not get to see them.
Yeah, I'm not referring to you, though. At one point you said that the commission, that these were not available to the commission, that this was withheld from the commission. My question is, did the commission decide not to look at the material, or was it withheld by some other decision from the commission? That's and if you don't remember the answer, that's fine, no, but there is a difference.
I do not remember. It is a matter of an inference as to what happened. I did not sit in the commission meetings because I was not on the commission. And it may be that those records are all present and there is an answer, but I have not reread all the commission records. I do know that there was a concern about having the photos and X-rays get into the public domain, and that when I asked for them very forcefully in these memoranda, that I did not have access to them. And I know that there was nothing in the Warren report, and when the Warren report was written, I do not believe anybody on the commission had seen the photos or the X-rays. And
that
later,
might have been at their own choice.
Of course. The commission had subpoena power, and the commission could have made a decision to...
if they didn't see them, it may have been their decision not to see them.
That's correct, and that's why I said that it may well have been what the commission decided to do.
Thank you. That clarifies.
Senator Lieberman, anything additional?
Very briefly, Mr. Chairman, and in light of your desire to move on, which I agree with, of course, I'll pose just maybe a series of statements, not requiring a response. I want to ask this panel, which has shown real leadership here, if it would do us the kindness of going back and looking at the specific terms of Section 6 of the proposed bill, which offer grounds for postponement of disclosure, just to make sure that they are consistent with the very strong statements that you've all made in favor of disclosure. I mean, for instance, you've used an artful word there, postponement, instead of denial. And instead of saying disclosure may be denied, you've said postponed. I'm curious as to whether we ought to, how long the postponement will be. Will it be until the national security or privacy are no longer threatened? Do we want to require a mandatory review every 2 years? And going along, some of the language is fairly broad. We had the exchange here a few moments ago about an intelligence agent. Then there's another section that gives us an exception, an intelligence method which is currently utilized or reasonably expected to be utilized. The one that troubles me most, although I know there's a reason for it, but I just am concerned about the doors it may open is an invasion of privacy of a living person, whether that person is identified in the material or not. And I'm concerned about that being used as a ground for requesting postponement of disclosure. So I think, consistent with all that you've said here, I hope that you'll give us the benefit of your second look at that Section 6 of this proposed act.
Good. Thank you very much. We may have additional questions. Been a long session this morning here, and we may have additional questions from other members or questions after we review. We'd appreciate an early reply so it could be included in the record. Thank you very much. Appreciate it. Next panel, the Honorable Robert Gates, Director, Central Intelligence Agency, and the Honorable William Sessions, Director, FBI. Gentlemen, you've been very patient here this morning. I know we had told you you'd be on by about 10 o'clock here. We're about an hour late on that, or a little over. So we appreciate your forbearance this morning. Look forward to your testimony this morning. Mr. Gates, if you'd lead off, we'd appreciate it very much.
Thank you, Mr. Chairman. Mr. Chairman, I'm here today at your request to provide my views on Senate Joint Resolution 282, the Assassination Materials Disclosure Act of 1992, and to describe the nature of the documents held by the Central Intelligence Agency that relate to the assassination of John F. Kennedy.
Pull the mic just a little bit closer. Thank you.
I very much appreciate the opportunity to speak on this important matter. Let me begin by stating that I am in complete agreement with the purpose underlying the joint resolution, that efforts should be made to declassify and make available to the public as quickly as possible government documents relating to the assassination of President Kennedy. We hope that opening up and giving journalists, historians, and most importantly the public access to governmental files will help to resolve questions that still linger over 28 years after the assassination. Further, I believe that maximum disclosure will discredit the theory that CIA had anything to do with the murder of President Kennedy. Even before the introduction of this joint resolution, I recognized the need for greater public access to CIA documents of historical importance. 2 months ago, I announced the establishment of a new unit within CIA that will be responsible for declassifying as many historical documents as possible, consistent with the protection of intelligence sources and methods. This new unit, the Historical Review Group, in the agency's Center for the Study of Intelligence, will review for declassification documents 30 years old or older and national intelligence estimates on the former Soviet Union that are 10 years old or older. In addition to the systematic review of 30-year-old documents, I have directed the history staff in the Center for the Study of Intelligence to assemble CIA records focusing on particular events of historical importance, including the assassination of President Kennedy. Historical Review Group will then examine the documents for the purpose of declassifying the records. Because of high interest in the JFK papers, I am not waiting for legislation or other agencies to start declassifying documents belonging to CIA. The Historical Review Group, at my direction, already has begun its review of the documents related to the assassination of President Kennedy. And I'm happy to report that the first group of these records, including all CIA documents on Lee Harvey Oswald prior to the assassination, has been declassified with quite minimal deletions and is being transferred to the National Archives for release to the public. This is, I acknowledge, a small fraction of what we hold, but it is an earnest of my commitment immediately to begin review for declassification of this material. And indeed, as I speak, the reviewers are going through a substantial number of documents, and I anticipate that many of these will be released shortly. As we carry out our program to declassify Kennedy assassination documents, our goal will be to release as many as possible. In fact, I recently approved a new CIA declassification guideline for our historical review program, which specifically directs a presumption in favor of declassification. I believe we can be very forward-leaning in making these documents available to the public, and I have instructed the Historical Review Group to take this attitude to heart. In this spirit, the agency today will make publicly available these new guidelines for historical review and declassification. To understand the magnitude of the effort involved in reviewing these documents for declassification, it is important to place them in some context. CIA's collection of documents related to the assassination of President Kennedy consists of approximately 250,000 to 300,000 pages of material. This includes 64 boxes of copies and originals of information provided to the Warren Commission and the House Select Committee on Assassinations, and 17 boxes of material on Lee Harvey Oswald accumulated after President Kennedy's assassination. Unfortunately, and for reasons that I do not know, what we are dealing with is a mass of material that is not indexed, is uncatalogued, and is highly disorganized, all of which makes the review process more difficult. The material contains everything from the most sensitive intelligence sources to the most mundane news clippings. These records include documents that CIA had in its files before the assassination. A large number of records that CIA received later as routine disseminations from other agencies, as well as the reports, correspondence, and other papers that CIA prepared in the course of the assassination investigations. I should emphasize that these records were assembled into the present collection as a result of specific inquiries received from the Warren Commission or the House Select Committee on Assassinations. Prior to President Kennedy's assassination, CIA held only a small file on Lee Harvey Oswald that consisted of 33 documents amounting to 110 pages, some of which originated with the FBI, the State Department, the Navy, and newspaper clippings. Only 11 of these documents originated within CIA. I brought along a copy of Oswald's file as it existed before the assassination, so that you can see firsthand how slender it was at the time. As I've already noted, we've declassified the CIA documents in this file with quite minimal deletions, and we are providing them to the National Archives. The records in this file dealt with Oswald's defection to the Soviet Union in 1959 and his activities after his return in 1962. By contrast, it was only after the assassination that CIA accumulated the rest of the material on Oswald, some 33,000 pages, most of which CIA received from other agencies after November 22, 1963. The committee has asked about documents in our possession generated by other agencies. In fact, much of the material held by CIA originated with other agencies or departments. For example, in the 17 boxes of Oswald records, approximately 40% of the documents originated with the FBI, and about 20% originated from the State Department or elsewhere. Our staff is still going through the material compiled at the request of the Warren Commission and the House Select Committee on Assassinations, which includes 63 boxes of paper records and one box that contains 73 reels of microfilm. The microfilms, in part, overlap material in other parts of the collection. We estimate that within the 63 boxes of paper records, approximately 27% originated with a variety of other U.S. government agencies, private organizations, and foreign and American press. Although our documents do include many documents from other agencies, we nonetheless have a substantial collection of CIA documents that will require considerable effort to review. And as I said earlier, at my direction, this review for declassification is now underway. A preliminary survey of these files has provided us some indications of what they contain. Although the records cover a wide variety of topics, they principally focus on CIA activities concerning Cuba and Castro, Oswald's defection to the Soviet Union, and Oswald's subsequent activities in Mexico City and New Orleans. They also include a large number of name traces requested by the staff of the House Select Committee on Assassinations, as well as material relating to the Garrison investigation and Cuban exile activities. CIA cannot release a number of documents unilaterally because of the limits in the Privacy Act which protects the names of American citizens against unauthorized disclosure, the sequestration of many documents by the House Select Committee on Assassinations, and the fact that many of the documents belong to agencies other than CIA. However, we have already taken steps to lift the sequestration, to coordinate with other agencies, and to begin the process of declassification. If necessary, in the absence of legislation, I will ask the House of Representatives for a resolution permitting CIA to release the results of the declassification effort on the sequestered documents. While I expect a large amount of the material can be declassified under our program, I assume that there will be information that cannot be released to the public for a variety of reasons, including privacy concerns or the exposure of intelligence sources and methods. Let me take a moment to give an example of this type of material. During the investigation by the House Select Committee on Assassinations, I understand that security and personnel files were requested on a number of CIA employees. These files contain fitness reports or performance evaluations, medical evaluations, and credit checks on individual CIA officers. Although irrelevant to the question of who killed President Kennedy, these and other personal documents ultimately ended up in the sequestered collection of documents. I do not believe that the benefit to the public of disclosure of this information outweighs the clear privacy interest of the individuals in keeping the information confidential. Similar privacy concerns exist with documents containing derogatory information on particular individuals where the information is based on gossip and rumor. Our files also contain the names of individuals who provided us intelligence information on a promise of confidentiality. We would not disclose their names in breach of such a promise. Where we cannot disclose such information to the public, the agency will make redactions and summarize the information in order to ensure that the maximum amount of information is released while still protecting the identity of an agent or the privacy of an individual. If legislation is not passed by the Congress and signed by the President regarding the JFK papers, to enhance public confidence and to provide reassurance that CIA has not held back information relevant to the assassination, I would appoint a panel of distinguished Americans from outside of government, perhaps including distinguished former jurists, to examine whatever documents we have redacted or kept classified. They would then issue an unclassified public report on their findings. The effort required to declassify the documents relating to the assassination of President Kennedy will be daunting. However, it is an important program, and I am committed to making it work. Even in a time of diminishing resources within the intelligence community, I have allocated 15 full-time positions to expand the history staff and to form the historical review group that will review the JFK documents and other documents of historical interest. I believe these actions attest to the seriousness of our intent to get these papers declassified and released, and to open what remains classified to outside, non-governmental review. It is against this background that in response to the committee's request, I cite our few technical reservations about the mechanism established by the joint resolution to achieve this same result. I intend to address only intelligence community concerns. I will defer to the Department of Justice on any additional problems posed by the joint resolution. First, vesting in an outside body the determination as to whether CIA materials related to the assassination can be released to the public is inconsistent with my own statutory responsibility for the protection of intelligence sources and methods. Second, I'm concerned that the joint resolution contains no provision requiring security clearances or secure document handling by the Assassination Materials Review Board or its staff. Third, I'm concerned that the joint resolution does not provide the agency with the opportunity to object to the release of CIA information contained in documents originated by Congress or the Warren Commission. Under the joint resolution, documents originated by these entities can be released directly by the Executive Director of the Assassination Materials Review Board without any review by the President or other executive branch agencies. Fourth, the joint resolution provision for a 30-day period for agencies or departments to appeal decisions by the Executive Director to release information may not provide sufficient time for meaningful review of what could prove to be a large volume of material at one time. Fifth and finally, Section 6 of the joint resolution, which outlines the grounds for postponement of public release of a document, makes no provision for postponing release of documents that may contain executive privilege or deliberative process, attorney-client, or attorney-work product information. While such privileges could be waived in the public interest, and in fact are not likely to arise with respect to factual information directly related to the JFK assassination, they would be unavailable under the joint resolution in the rare case they might be needed. These are the technical problems that I believe can be solved and that will in fact expedite the release of documents bearing on the assassination of President Kennedy. But again, whatever the future course of this legislation, CIA is proceeding even now to review for declassification the relevant documents under its control. Further, we will cooperate fully with any mechanism established by the Congress and the President to declassify all of this material. Mr. Chairman, let me close with a comment on why I am personally committed to get these documents out. Like all Americans old enough to recall that terrible day in November 1963, and as several members of the committee have alluded to, I also remember where I was and what I was doing. I was a college student at William & Mary, and I can remember how the word spread like wildfire between classes of that horrible event. I made my way to Washington that weekend and stood at the intersection of Constitution and Pennsylvania Avenues, where I waited for hours to watch the President's funeral cortege. I will never forget it. I entered public service less than 3 years later, heeding President Kennedy's inaugural call, a call I think many of my generation heard. He said then, "Now the trumpet summons us again, not as a call to bear arms, though arms we need, not as a call to battle, though embattled we are, but as a call to bear the burden of a long twilight struggle, year in and year out, rejoicing in hope, patient in tribulation, a struggle against the common enemies of man, tyranny, poverty, disease, and war itself." Mr. Chairman, the only thing more horrifying to me than the assassination itself is the insidious, perverse notion that elements of the American government, that my own agency, had some part in it. I am determined personally to make public or to expose to disinterested eyes every relevant scrap of paper in CIA's possession in the hope of helping to dispel this corrosive suspicion. With or without legislation, I intend to proceed. I believe I owe that to his memory. Thank you.
Thank you, Mr. Gates. Mr. Sessions?
Good morning, Mr. Chairman, members of the committee. I have a complete statement which I will file, and there are some diagrams which I will also make available for the record, and a photograph of the files themselves.
Without objection, your entire statement will be included in the record.
Thank you, Mr. Chairman. I'm pleased to appear before you to testify about FBI investigative records relating to the assassination of President John F. Kennedy. I applaud this process and your efforts. It is fundamental that government exists to meet the needs of its citizens. The examination of these issues is directly related to satisfying the intense interest and concern of our citizens about the circumstances surrounding that tragic event some 29 years ago. From the outset, I would like to state emphatically that I favor maximum disclosure consistent with the law and the legitimate need to protect certain small but highly sensitive categories of information. I can assure you that the FBI will work cooperatively through the Department of Justice with both the Senate and the House to develop a comprehensive approach to these important issues. As you know, the government has conducted a number of reviews of the assassination. The Warren Commission, the House Assassinations Committee, and the Church Committee all conducted reviews that I believe can be best characterized as exhaustive. It is my understanding that the FBI provided massive amounts of information to those entities to help ensure that they accomplish their missions. Once again, we desire to be as helpful as we are able. Immediately following the shooting of President Kennedy, the FBI began a massive investigation. An intense effort was made. Related investigations were conducted, and much information was exchanged, as Director Gates has noted, between the various agencies. As is the case with all major investigations, thousands of pages of documents were created to record the results of these efforts and to facilitate the investigations. Many different kinds of information were recorded in the FBI files. The results of thousands of interviews of witnesses, other individuals with possible helpful knowledge, and contacts with confidential informants were memorialized. Communications between the FBI headquarters and our field offices, and vice versa, were included, as were communications between the FBI and other agencies. Forensic reports were recorded. In all, FBI files relating to the assassination contain over 499,000 pages of documents, with a few more pages added every time the FBI follows up on a new allegation or a new issue arises. After Congress amended the Freedom of Information Act in 1974, the FBI began receiving requests for information relating to the assassination. By 1978, 4 years later, over 200,000 pages of material had been processed and made available to the public through the FBI's public reading room. Many authors, journalists, historians, and others have visited and revisited these materials, which remain available today as a valuable source of historic information. I would like to briefly describe to the committee a breakdown of FBI records relating in some way to the assassination. The FBI has 4 core files that relate directly to the investigation of the assassination. Our cooperation with the Warren Commission and the investigations of Lee Harvey Oswald and Jack Ruby. Those are the 4 core files. There are approximately 499,000 pages in these files, 263,000 of which are duplicate pages that were cross-filed, third agency records, and some FBI records that have not been processed pursuant to the Freedom of Information Act. Approximately 223,000 pages, or 94% of the records we have processed, have already been released to the public. In addition, the FBI has several other much smaller files as a result of other directly related investigations, such as the investigation of Marina Oswald, and these files comprise approximately 22,000 pages, 13,000 of which are duplicate, third agency or unprocessed pages. 58% of these pages processed pursuant to the Freedom of Information Act have been released to the public. Of the pages available in the FBI reading room on the main floor at FBI headquarters, approximately 189,000 pages, or 94%, are available in their entirety. The remaining 12,000 pages in the reading room reflect some degree of redaction. The information that has not been disclosed or that has been redacted to some degree falls within the exemptions that are enumerated in the Freedom of Information Act and the protections of the Privacy Act. This includes information that, 1, is classified on the basis of national security, 2, would disclose the identities of individuals who specifically requested confidentiality, 3, would disclose the identities or confidential informants or sources, 4 is highly personal information about individuals, or 5, originated with other government agencies, and those agencies specifically requested that the information not be released based upon exemptions applicable to those particular agencies. While I strongly favor maximum disclosure under the law, there are certain types of information that are particularly critical to successful law enforcement investigations and national security. For example, information that is properly and appropriately classified, information that would identify confidential sources, and information that would disclose sensitive investigative techniques are the types of information the disclosure of which could negatively impact upon our ability to fulfill our mission. Information in FBI files that has not been disclosed publicly falls largely within these descriptions of information. In any case, I believe it is extremely healthy for the country to have these issues aired and to be resolved. The public interest dictates a final review of this horrific event. Maximum disclosure, consistent with the law and the legitimate need to protect very limited amounts of sensitive information, best serves that purpose. I have spoken to my colleague, CI Director Bob Gates, who sits beside me, and others within both the executive and the legislative branches. I have heard no one express an opinion to the contrary. I know that represents the position of the Department of Justice. I applaud the task you are undertaking, and I can assure you that the FBI has been and will be working vigorously to do our part in this matter. Thank you very much.
Thank you very much. Mr. Gates, the information that you indicated was being sent to the archives today, now will that be releasable? Is that released when it's sent to the archives, or will it still be under a classification?
No, it'll be declassified, Mr. Chairman.
Okay, will it be available over there or at CIA, or what will the availability to the public, how soon will that be available to the press and to the public?
I think it'll be through the archives, and I would assume almost immediately, within a day or two.
All right, fine. We already have one copy here, committee copy here we have, but we don't have them for release yet here. It'll be available over there, I guess. Are either of you aware of an effort underway by the White House to issue an executive order to release executive branch records on the assassination? Mr. Sessions?
I am not, Mr. Chairman. It may be that the Department of Justice, whose representative, Mr. Leach, is here this morning, would have knowledge of that. I have no such knowledge.
Is Mr. Leach here?
Mr. Leach is a Deputy Assistant Attorney General from the Office of Legal Counsel, and he is here, and he may know of such a matter.
Is there an executive order underway or being contemplated, do you know, Mr. Leach?
Mr. Chairman, in an effort to achieve the shared goals of full possible disclosure here, we have considered all the various options that might work that result. An executive order is certainly one of the options that has been discussed.
Was that being actively put together now?
There is an effort underway to see if that would work. Yes.
When would that be put out? Do you know?
I don't have that information.
Okay. But Mr. Sessions, you're not aware of details of that?
No, sir, I am not.
Mr. Gates?
I heard in preparation for the committee that that might be a possibility, but I don't know anything further beyond that.
Okay, Mr. Leach, do you know how it would compare with what the legislation is that's before us this morning?
I don't know specifically. I do think that various options have been discussed that would set up a review process internal to the executive branch for those materials that are held by the executive branch. Okay. But since it's still in the drafting and consideration stage, it remains to be determined.
Yeah, Mr. Sessions, the Department of Justice wants the Congress to add the law enforcement exemption contained in the Freedom of Information Act to the bill. It was added 1986. In discussions with your staff, the committee was told that this exemption has not only narrowed the flow of Kennedy assassination information since 1986, but that if it had been in place prior to 1986, that instead of 90% of pages of documents being unredacted, that only about 25% would have been unredacted. In other words, 75% of the material would be blacked out. What's the rationale then for adding the exemption to a process which is designed to open, not close the records?
Mr. Chairman, the law enforcement exemption and the reasons for that are, of course, extremely broad. My belief is that persons, for instance, who would know of or learn of particular techniques that were utilized in law enforcement, if that happens, it would be detrimental to law enforcement generally. But I would stand on the general proposition that is being expressed so openly here this morning, that is, that we in the FBI should be prepared with particularity to defend a particular piece of information and the necessity of it not being divulged. The day that I was notified that there might be this review because of the JFK film, I indicated then that the FBI stood ready to comply with the law as it was enunciated by the Congress and the President of the United States. We stand ready still to do that and to defend those parts that we believe should be withheld.
The bill contains very specific exemptions which cover sources and methods of intelligence gathering or FBI work, covers confidential sources and witnesses, privacy standards which extend to living persons, and more. But you don't feel that these are adequate protections. Is that correct?
I believe that those are the bases for the adequate protections and that we ought to look at each of them very carefully. And if the suggestion is for disclosure and the FBI does not agree with it, then it would have the burden placed upon it exactly as I think the resolution expects. That is, that we should put forth the reason and take the burden of going forward with declaring that reason and the importance of it in order to protect the information.
Mr. Gates, do you have any similar concerns with regard to CIA, or do you think there are adequate protections in this legislation?
I think the protection of sources and methods, both as described in the bill and by Senator Bourne and as I've described them, are probably adequate.
The legislation appears to lump together human and technological sources and methods of intelligence gathering. Does that, on the type of information that could be released, is there any differentiation there, or are there other considerations there, or could those be lumped together?
I know of no reason, without further reflection and consultation, Mr. Chairman, why they could not be lumped together. Overall sources and methods are usually considered together.
The legislation also proposes that the review board's executive director will identify the agency records relevant to the assassination. Now that's a matter of qualitative judgment there, or specific judgment relevant to the assassination. And some observers, including some of our witnesses today, may suggest that letting the agencies make the first cut will simplify and expedite the process, but others will think that this will defeat public confidence in the independence and accountability of the whole process. What's your view on this, Mr. Gates? Is that a problem?
Chairman, my view is that, or the CIA is prepared to accept a definition of material bearing on the assassination as that which might be reasonably connected to it. And I think, as I indicated in my prepared statement, we are prepared to consider within the framework of assassination materials virtually all of the materials identified in the course of both the Warren Commission investigation and the House Select Committee on Assassinations investigation. And as in light of the discussion earlier here in the panel, I'd note that that includes material on Cuba and Castro and other such, the activities of Cuban exiles and so forth. So I think it's a fairly broad definition that would encompass virtually all that has been taken into account in previous investigations.
My time is up on this round. Senator Roth.
FBI's perspective of that particular question.
Sorry, I meant to.
Thank you, Mr. Chairman. I think the suggestion has merit to allow an agency to come forward in a review and take those pages which it believes should be made public, and they are made public, and only to hold back those it believes should not be, would greatly reduce the burden upon the director of the commission itself. And therefore it does have merit and should be explored.
Thank you. Senator Roth.
Yes. If this legislation before us is enacted into law, and you did touch upon this in your testimony, could you give me an estimate of what it would require in personnel, cost, and estimated time to comply with?
I might be able to give you some indication, Mr. Roth. My belief is that it's well known that the Freedom of Information and Privacy Act creates a substantial burden upon the FBI. There's about $16 million relegated to it in our budget, and we have some...
How much was that? I'm sorry.
About $16 million relegated to it in the budget. There are some 188 persons, including 105 analysts, who work directly with that. By the way, that's a reduction in the last 10 years from about 220 that were in that position 10 years ago. The point is that those people, if taken off for this kind of investigation, immediately detract from our ability to answer the Freedom of Information and Privacy Act requests. Those are part and parcel of our business and making available to the public these very records about which we're discussing. So the costs that are related to it have to be measured in that sense, but also in the overall sense. The investigation in 1978 cost about $800,000. That is to go through those records and begin the disclosure process. The estimates that I would make would be that it would, if taken in 1992 dollars, and the 800,000 were then measured, it would be approximately $1,700,000. If you add an additional cost, there might well be as much of $250,000 additional that would be required in connection with our review of those records and our dealing with those records directly. I can't give you a firm estimate. It's just going from past experience.
What about time? How long do you think it would take you to complete the kind of investigation required under this legislation?
There are presently released 223,000 pages, of which 12,000 were withheld. Now, that means that the review of those could, I think, take place in fairly short order, certainly a matter of a few months, maybe 3 or 4 months it could be done. There are other non-related files. There are also files that are out in the field, some of which are duplicated by our records here at headquarters. But I think we would be looking at a matter of months, Senator, in order to be able to do that.
Mr. Gates?
Senator Roth, we, as I indicated in my prepared statement, I have established a unit of 15 full-time people working on the review and declassification of historical documents. I have made these papers their first priority. I don't have any estimate of what the cost would be. We would be prepared to deal with that. And I think that the overall time involved, particularly given the condition in which we find these records, probably would be between 6 months and a year to complete going through them all.
Can you give me some examples of what sort of material would not be disclosed under either FOIA or the resolution procedure? Would more material be released under one standard as opposed to the other?
I have established, as I indicated in my prepared remarks, we have prepared new guidelines for historical declassification. We are now proceeding to conform the guidelines for FOIA to those new, more forthcoming standards that begin with a presumption of declassification, particularly for 30-year-old material. I think that at least at the present time, the standards established under the new historical guidelines at CIA probably would yield more documents. But as I say, we are in the process of beginning to conform our other document review to that. I don't know how long that'll take.
Mr. Sessions?
Senator, as to properly classified matter that's classified pursuant to Executive Order 12356, we're talking about national security information, specifically, as you asked, because it relates to intelligence sources, intelligence methods, intelligence activities, intelligence information from foreign governments or foreign confidential sources. Other types that would not be included, we believe, should be material that is highly personal, such as home addresses and personal habits and medical information. And then, of course, most critical, I believe also, is the keeping confidential those confidential sources that have asked for confidentiality, because it's based upon that promise that the information was secured in the first place.
My time is about up, but let me ask you one final question. Assuming that we're going to enact the proposed legislation into law, are there any recommendations you have to simplify the process and get the same results?
Well, there was a suggestion made earlier. In fact, I think you may have asked the question yourself. Is there any way we can piggyback on the procedures that are listed under and followed under FOIPA? Well, the Freedom of Information Act has been a way of life in the Bureau for a long time. It's obvious that hundreds of thousands of pages are made available now, and the processes of reviewing those documents for that release is a very tedious, time-consuming effort, very carefully done, so that we are pretty well in shape because of the reviews that we have made to be well along the line to reviewing all the documents. And that process has proven to be very fruitful. I think, therefore, the suggestion that was made earlier in Senator Boren's testimony, that there might be a way to put some burden upon the agencies themselves to make that initial review, make available what they choose to, and what they choose to withhold, then have to justify it and give their rationale for it and the necessity for it before the Commission.
Mr. Gates?
Senator, I would agree with what Judge Sessions has said. I think that the idea of getting this material out as quickly as possible would be well served by reasonable time limits on the agencies to review and declassify documents, and then for the whatever panel or group is set up, if the legislation is passed and signed by the President, then to have to deal only with that material that's either been redacted or held back. So it would significantly reduce the burden on the panel and allow them, I think, to act much more expeditiously. That's a personal opinion.
Thank you. Senator Levin.
Thank you, Mr. Chairman. First, I wonder if we could get a little better idea as to the material which has been reviewed by the FBI. Can you give us an estimate of the total number of pages that you have and how many have been released?
Yes, I can do that. There are 499,431 pages so far as we know at this count, Senator. Of the pages that have been processed thus far,
if you could just stop right there, because that's where the confusion is. Can you tell us how many pages have not been processed, and then go from there to how many pages have been processed?
Yes, there are 263,639 pages that have not been processed. Many times that is because there has been no request, and some of those are files that, for instance, are out in the field offices. There are 102,000 pages out in the field offices that have not been processed here. I have the breakdown on what that 263,639 is made of, and I'll be glad to provide that for you.
That's fine. So the majority of the materials have not even been processed, much less released.
There are 263,000 pages that have not been processed nor released, and that's principally because there have been no requests for those.
Yes. For whatever reason, though.
Yes.
Okay. Now, we have the rest of the material, we have the rest of the figures, and that's a good answer to my question. I understand the balance of the figures.
What I've done,
I wanted to get to the...
is made available for you the charts that reflect those specific numbers as to both core files and as to the related files.
All right. Now, Director Gates has testified this morning that the historical review program that he has created in the CIA specifically directs a presumption in favor of declassification. Do you agree with that?
I have no argument with that, and I've testified this morning that I believe the burden should be upon us in the agency to justify withholding that which we believe must or should be withheld.
But in terms more precisely of directing that there be a presumption in favor of declassification, do you support there being such a presumption?
I think that it's very clear that everybody in a responsible position believes that there should be a presumption that it should be disclosed, but that then the burden falls upon the agency to actually justify the withholding of that information.
Now, do you believe that the executive branch should have a veto over materials in the possession of Congress?
In some instances, that is, I think, quite appropriate. For instance, if documents were provided in the assassination investigations that fall in that category, the information falls in that category which we believe should be withheld, it would make a nullity out of our withholding it if, in fact, the Congress was able to release it. So that I'm willing to bear the burden of going forward with the reasons why it must not be released, and I would think it would be sound not to have the Congress simply release those things which an agency believes must, for a very particular articulated reason, be withheld.
The answer to the question then is that you believe that you constitutionally have the right to veto under a privilege, or that you should be given that right under legislation?
Senator, I'll defer to the Department of Justice and its legal counsel here, or its rationale that it pursues.
All right, let's proceed then, because of our time limits. The FBI has apparently indicated that its continued investigation into the assassination, that it has uncovered 2 witnesses that were there that had previously not been interviewed, apparently. Can you tell us if that's true, and what did your investigation disclose? Apparently 2 hobos, as they were described then?
Without disclosing what the nature of the interviews were, that is correct. It is my understanding that there were additional people that were found that were from the police records, I believe from the police records there in Dallas, that disclosed those 2 people. There may have been 3, and I think they were interviewed, Senator. I have not reviewed the others, but I believe that's correct.
Can you tell us what the outcome of the interviews were?
It was essentially negative. That is, there was nothing that they could have added to the investigation, nor were they in any way involved.
Now, your testimony this morning is quite different in tone from the Attorney General's letter to the chairman. And I must tell you, I welcome that. But the letter of the Attorney General, number one, says it's going to be vetoed in its current form, this resolution. Number 2 is about 9 pages of single-space strenuous objections. The word strongly object appears so often that I stopped counting it, I think about 6 times. But it was a very negative letter from the Attorney General relative to this legislation. And at the end of that letter, in addition to threatening the veto, it said that we're developing an alternative draft resolution. Whereas your testimony this morning, again, is much more positive tone, and again, to emphasize, I welcome that tone. I think it's appropriate that the administration respond positively and try to work out what differences there are. But in your testimony, it says the Attorney General has asked me to communicate to you that the department stands ready to work with you to craft changes to the resolution. Do I then understand that we're not going to be receiving an alternative draft, but rather that the department is going to instead be attempting to work out differences by amendment?
First of all, it's not my responsibility to defend the Attorney General in his very careful laying out of objections that do occur in the process of review. It's a lawyer's responsibility to do that when he believes that in fact there are matters that need to be brought to the attention and considered. So I look on it, and I've read the letter, as a very careful review of what is proposed.
But my specific question is, will this now be done through seeking changes in this draft rather than submitting a totally different draft?
It is my understanding that the department stands ready to cooperate with the committee and with the Senate and the House, and Mr. Leach is here as an evidence of that they intend to pursue trying to work out those objections and the format in which the ultimate resolution would be presented.
All right. I think my time is up, and I'm afraid I don't want to cut in Senator Cohen, but the one I just want to make a statement in concluding. I haven't had a chance to ask you any question, Director Gates. I very much welcome your testimony this morning and the feeling and the emotion with which it was delivered. I think it's important. It reflects the feeling of the public as well, that we not allow any suggestion of cover-up or conspiracy to interfere with what we must know, which is the total truth. And the way you phrased it based on your own personal experience, I think is very compelling and reflects a determination on the part of all of us to get it all out there, except for very narrow exceptions, obviously, to protect certain compelling interests. But the feeling and the strength of your testimony, I think, is important, and I hope that carries through to an ability to pass legislation this session, which I hope just lays it all out there so that the public can judge, again, subject to very narrow exceptions, which the public would, I think, understand.
Senator Cohen. Mr. Chairman, I think, Senator Levin, what you're seeing is a kinder, gentler voice of the Justice Department coming forward this morning, as opposed to the letter you received. Mr. Gates, let me return to the Oswald file. I must tell you that in going back and reading all of the material on Oswald, not this particular file, but I found it rather difficult to comprehend a situation where you would have a Marine stationed in Japan who has access to U-2 flights, who defects to the Soviet Union, who marries a high-ranking, the daughter of a high-ranking KGB officer, who then redefects to the United States and then takes up residence here. That throughout that time, according to the testimony that I've read in the past, no one from the KGB ever interviewed Mr. Oswald. We had a situation shortly after he redefected to the United States and President Kennedy was assassinated. We had the defection of Yuri Nosenko, a very famous case that you're familiar with involving James Angleton and what unfolded from that. And so there were great doubts that developed that saying, didn't someone ever talk to Lee Harvey Oswald in the Soviet Union? In this resolution under Section 10, there's a non-binding sense of the Congress that calls upon the Secretary of State to contact the Russian government to seek the release of all KGB and GRU documentation that's relevant to the Kennedy assassination. Could you tell us whether or not you've had any contact with any of the Soviet officials, whether working through the State Department or through the CIA, whether there has been any indication on their part that they are willing to reveal their files, and if so, whether those files have any information that would be helpful in this entire investigation?
There has been no contact between CIA and the Russian KGB on this matter. I would have to check and provide an answer for the record for the committee whether someone from the State Department has made a request of the Russian government for those archives. I think that may have happened, but I'm just not certain.
Would you, in your experience, find that equally hard to believe that someone with a military personnel defects to the Soviet Union and marries a Soviet or a Russian woman, a daughter of a KGB official, that if someone would contact that individual to either brief him, debrief him, whatever?
Just speaking in very broad and generic terms, I would think it unusual not to have had some contact, but I don't know in this case.
You both mentioned, I think, Director Sessions and Director Gates, you both mentioned there might be a situation where you want to protect medical records. Let me, of individuals who are involved because of privacy concerns. Let's suppose you have an agent who has knowledge of some aspect of the Kennedy assassination, and that particular individual has a record of mental instability, and might call into question his or her veracity or reliability. Would the interest in protecting the medical records outweigh that of someone assessing the reliability of that individual who may have provided information be weighed?
Part of the dangers of having a non-lawyer answer these questions is that I'm inclined to answer them. My reaction to that on a purely hypothetical basis would be that if the information from the source were indeed germane, then I think that would fall into the category that I described and that I think Senator Bourne referred to, where we ought to be able to find some way, without revealing the identity of the source, to reflect on our level of confidence in the source.
Okay. I'm going to give you a chance in a moment, Judge Sessions. I just want to move on quickly because we have Mr. James, I think, Lazar, who's going to be testifying shortly, and I will not be here for that either. But he questions the issue of intelligence sources, that the bill provides that disclosure can be postponed if the release of that information would reveal an intelligence asset. And Mr. Lazar suggests that, number one, that should apply only if that particular agent is living. And then secondly, even if living, that the burden would be upon the agency to present by clear and convincing evidence that disclosure of the identity of that particular agent would in fact present a danger to him or to his family, I assume, or serious damage could result from the disclosure of his identity. Could you, number one, give us some instance in which disclosure of a deceased intelligent agent or asset would be contrary to our national security interests, and then secondly address the issue of clear and convincing evidence that the agent being alive, that he might be jeopardized by that disclosure?
At the root of effective intelligence work is our ability to deal with people who are willing to provide us with information and to assure them of confidentiality, that their identity will be protected. The Congress has recognized that. The Congress has even recognized the importance of protecting the covert identities of American case officers dealing with such foreign agents. I believe that we have an obligation to protect the confidentiality of our sources regardless of the amount of time that has passed. And I believe that if the agent is deceased, that we also have to take into account the potential considerations for that agent's family. There are many countries in the world today in which, despite whatever political changes have taken place, families of those who have defected or who have been proven to be agents or who are revealed to have been agents are persecuted or maltreated, or where their life becomes much more difficult. And I think we have an obligation to these people. I think we are not in a position of saying never, but I think that any decision with respect to revealing the identity of a source or an agent, even 20 or 30 years after the information was reported, is one that has to be taken with enormous care and deliberation. One that must involve knowledge of the particular circumstances involved, both at the time the information was received and the circumstances of the agent and his family. In short, so important is the ability to protect the confidentiality of sources that a decision to reveal that identity would have to be the result of the most careful consideration.
Okay, my time is up. Thank you, Mr. Chairman.
Thank you, Senator Cohen. Let me associate myself with the remarks of Senator Levin with regard to your remarks, Mr. Gates, in particular the last part. That was very forceful, a very fine statement, and I wanted to associate myself with Senator Levin's remarks to you on that. Mr. Leach, I don't know whether you came prepared to talk about the letter this morning and all that, but I shared Senator Levin's views of the letter. It was an extremely strong letter, that it was so strong that I interpreted it one of two ways. Either the administration is really, truly against the release of information, doesn't want to release information, and is throwing up all sorts of roadblocks here to prevent it, because the administration has not basically been forthcoming in the release of information that could be released and should have been released possibly years ago. So it's either that, or this is viewed here, or I would view it, as possibly a holding action to delay until this executive order that's being prepared over there has a chance to come out and sort of preempt this legislation. Now, I don't know whether that's a fair assessment or not, but this was a very, very strong letter. It didn't agree with much that has been proposed in this legislation, I must say, and raised all sorts of constitutional grounds, prerogatives, presidential prerogatives. It's just across the board here, and I won't bother. It's a very lengthy letter. Encroachment on is unconstitutional under existing Supreme Court precedent, and executive branch information cannot be so limited, and a whole bunch of things in here, and then winds up saying that the bill as written would probably be vetoed. Is that still the view of the administration?
Well, Mr. Chairman, we have, as expressed in our letter, some serious reservations about parts of the bill as written.
That's the understatement of the morning.
However, I would note that our letter also expressed our willingness to work with the Congress in fashioning amendments or alternatives, and we stand ready to do that. We are, the Department of Justice is committed to the purpose of the legislation, which is stated in Section 2, to secure the expeditious disclosure of records relevant to the assassination as soon as practicable, consistent with the public interest. And To the extent our letter conveyed that we were not ready to do that, I think it was a misimpression. We are ready to work with the Congress to address our concerns, which, though we view them as important, are somewhat technical and we think can be corrected without sacrificing any interest in disclosure.
Well, we're happy to work together on this, but as the bill is written right now, you'd recommend a veto, is that correct?
I believe what the letter says is that the Department would consider recommending a veto.
Well, I'd have to look at specific language here, but there's no doubt about the veto recommendation. Not that the exact wording makes that much difference, but...
We would give serious consideration.
Yeah, serious consideration recommending presidential disapproval. Okay, you're right. Now, with that, can you run through very briefly, just summarize for us the parts of the legislation that you disagree with so strongly that you would recommend a veto?
Our concerns are basically of two types. The first is the appointment mechanism for the review board and its executive director. As I mentioned, I think those are somewhat technical. Senator Boren this morning has suggested some proposed alternatives to that we would certainly be happy to look at and consider. The concern is that the appointment of the review board and also the appointment by the review board of the executive director may be inconsistent with the appointments clause of the Constitution as we understand it after Morrison v. Olson and the more recent case of Freitag versus the Commissioner, which was decided by the Supreme Court last year. Our second concern is one that also has been expressed this morning by Senator Boren, among others, and that is that in attempting to enumerate the standards in Section 6 for postponement of disclosure, we agree with the sense of the resolution that there may be rare instances in which disclosure should be postponed in the public interest. We do think, as everyone has expressed, that they would be extremely rare. However, it would be, I think, not responsible for us to try and address all the possible situations that might occur in the legislation, and we think there are some areas, as have been mentioned this morning, where the standards in Section 6 might be improved.
Okay, we're going to have to move along here. I hope you would respond to any additional questions we may have so we can include them in the record. We may want to respond to the Justice Department letter so we clarify some of these things that we don't have time to really go into in real detail this morning. So we can get together and work this thing out. I think we're trying to all work to the same objective on this thing. The letter left us a little bit in doubt, perhaps, as to whether that was true. But perhaps we can get together on that and get a satisfactory resolution of our differences here so we can move ahead with this. Thank you very much, gentlemen. I'm sorry it took so long this morning here. I know we had told you you'd be on by about 10 o'clock, and so I hope we didn't delay some of your other appointments too badly this morning. Thank you very much. Thank you. Our next panel is Mr. James Lazar, President, Assassination Archives and Research Center of Washington, Professor Ernest May, Kennedy School of Government, Harvard, Professor Ethan Theoharis, Department of History, Marquette University, Milwaukee, Wisconsin. Gentlemen, if you could take your place at the table, we'd appreciate it very much. Yeah, I think so. We ought to clarify this with the people out there. Can we refer people to our request on the files? Can we refer them to archives?
Yeah, you can have some.
Yeah, we have one copy here, but I don't...
We have 5 copies.
Well, we're not going to start passing them out because then we should get... The normal procedure is to get... Yeah. Well, he said it should be releasable. I asked him that.
They're declassified right now.
Yeah. So it's just a matter of who's going to print up the things.
Right.
Okay, good. Thank you, gentlemen. Mr. Lazar, if you'd lead off, appreciate it. Very patient. Been a long morning here. Appreciate your patience. I hope you've had patience this morning anyway. Thank you.
Thank you. Mr. Chairman and members of the committee, I'm honored to have this opportunity to testify before you on the legislation to require the government to release its records pertaining to the assassination of President John F. Kennedy. I appear on behalf of the Assassination Archives and Research Center, the AARC, of which I am president. The AARC is a private, nonprofit organization which collects, preserves, and disseminates information on and materials on political assassinations. The AARC is funded by membership dues and donations from the public. I am an attorney specializing in Freedom of Information Act litigation and have litigated well over 100 such lawsuits. Over the past 20 years, I have represented nearly all of the major authors and researchers who have litigated Freedom of Information Act requests for records pertaining to the assassination of President Kennedy. To date, I have handled over 50 such lawsuits. I have carefully studied the proposed legislation. I have also read the letter that you received from the Department of Justice. I have heard that the administration may seek to achieve its goals, particularly that of using more restrictive standards for release of executive branch records by issuing an executive order rather than awaiting action by Congress. In my mind, the only thing worse than seeing the Justice Department's wishes granted in legislation would be to see them set forth in a standalone executive order which goes unchallenged by Congress. Legislation is needed to bring each branch of government which holds records onto the same playing field and to create a process which is accountable, independent, and credible. Incorporating the Justice Department's restrictive standards in an executive order would duplicate the devastating damage to the ideal of full disclosure which occurred when the Reagan administration successfully sabotaged the 1974 amendments to Exemption 1 of the Freedom of Information Act by drastically altering the standards for classifying information in the interest of national security. The difficulty which researchers have had gaining access to Kennedy assassination materials amply demonstrates the need to alter the standards employed by the FOIA and the current executive order on national security classification. If you support release of the Kennedy assassination records, you cannot favor the Justice Department's recipe of simply mixing 1 part political will to 3 parts of existing standards and stir. You must substantially liberalize the existing standards and make it stick. A few illustrations from my practice will show the inadequacies of the FOIA and the enormous frustration which accrues to those who attempt to use it to obtain information about the Kennedy assassination. These examples reveal a pattern of delay, costly litigation, and untrue representations by the government. Cases brought in the 1980s also show the massive withholding of information with little significant information being released. Case 1. In 1969, Harold Weisberg, a leading Warren Commission critic, made a simple request to the FBI. He wanted to see the results of the spectrographic tests which had been conducted on bullet fragments and items of evidence allegedly struck by bullets during the assassination of President Kennedy. Denied access by the FBI and the Attorney General, in 1970 he brought suit. A 4-year legal battle ensued. First, the district court, relying on the Justice Department's representation that it was not in the national interest to release the results of these scientific tests, denied his request. A Court of Appeals panel reversed, but the dissenting judge wrote a scathing opinion in which he referred to FOIA requesters as rummaging writers and characterized Weisberg as some party off the street. Stating that the FOIA fended against Weisberg's proposed further inquiry into the Kennedy assassination, he concluded his dissent with a Latin phrase, all in capital letters, requiescat in pace, rest in peace. But the case did not rest in peace. The Justice Department sought a rehearing before the full court, which was granted. On rehearing en banc, the full court ruled that the files of the FBI were exempt from the FOIA's disclosure requirements. That case set a precedent so bad that when Congress first amended the FOIA in 1974, it specifically overturned the Weisberg case, requiring that the FBI and other law enforcement agencies demonstrate that allegedly exempt records fall within one of 6 enumerated harms. In 1975, when the new amendments took effect, Weisberg again brought suit on his request for the spectrographic analyses, this time adding a request for neutron activation testing on the same evidentiary items. This new phase of the battle lasted 8 years and involved 3 trips to the Court of Appeals. Weisberg obtained important records on these scientific tests, including records that the FBI had first said did not exist, then claimed were missing or destroyed. Other records were never located or were meaningless. From the date of the first request, the legal battles lasted 14 years. Case 2. In 1980, another requester asked the CIA to release all of the records it had made available to the House Select Committee on Assassinations. The CIA refused and the requester brought suit. In court, the CIA stated that there were approximately 300,000 pages of records responsive to the request. I spent the first 3 years of this lawsuit litigating 4 threshold issues raised by the government. Had my client lost on any one of these 4 threshold issues, the CIA would not have had to release a single page from its 300,000 page collection. By 1984, the CIA had begun to release a trickle of documents. Although it told the court that it had assigned 7 people to work on the request, it processed the documents at an incredibly slow pace. When it became evident that it would take the CIA several decades to process all the documents, the requester had no choice but to drastically limit the scope of his request. Thus, he entered into a stipulation which restricted his request to some of the subjects discussed in the report of the House Select Committee on Assassinations and its supporting volumes. Although the CIA's job of reviewing documents was reduced by more than 1/2, it took several more years for it to complete processing of the remaining documents. Moreover, the CIA continued to withhold virtually everything. Only a few thousand pages were released, and most of them consisted of newspaper clippings, records that had previously been released, or documents that were heavily redacted. Case 3. In 1976, Dr. Paul Hoch requested 2 batches of CIA documents which had remained to be processed after the CIA had made its initial release of Kennedy assassination documents. Many of the records responsive to this request related to the 1966-1969 investigation and trial of Clay Shaw by New Orleans District Attorney Jim Garrison, who charged that Shaw, David Ferry, and others had plotted to kill the president. The CIA repeatedly told Hoch that his request was being processed and that if he would only be patient, the documents would be released in a few months, in 6 to 8 weeks, in the near future. Indeed, Hoch received such assurances on no less than 11 different occasions over a 6-year period. After having been strung out for 6 years, Hoch retained counsel and filed suit. After the suit was filed, evidence was developed which indicated that all the CIA had done over the previous 6 years was to number the documents. It had numbered several documents 1 month, a few more another month, a couple more the next month. Then, in 1 month, it engaged in a veritable orgy of numeration, numbering, as I recall, close to 100 documents. A few months after Hoch filed his complaint in district court, the CIA produced 808 pages. It also continued to withhold a considerable volume of materials, mostly on national security, or because disclosure allegedly would identify intelligence sources and methods. The district court upheld all of the CIA's exemption claims save one. This one was an 11-page memorandum which the CIA swore must be withheld in its entirety under Exemption 5's deliberative process privilege. The judge ordered this anonymous, undated memorandum disclosed. Then things got really interesting. The CIA moved the judge to reconsider his order on this memorandum, asserting that it had claimed, albeit obscurely, that this document was also withheld in its entirety under Exemptions 1 and 3 in order to protect national security and intelligence sources and methods. But before the court could act on the motion to reconsider, the CIA rushed back to court with a new revelation. The 11-page memo, which dealt with CIA mafia plots against Fidel Castro, matters exposed by the Church Committee in 1975, had been released nearly a decade earlier by the CIA itself. Case number 4. In 1969, Harold Weisberg made a request for FBI records on the assassination of Dr. Martin Luther King, Jr. It was ordered, apparently by J. Edgar Hoover himself, that no response be made to this request. In 1975, when the amended FOIA became effective, Weisberg submitted a new request for King assassination records. He specifically included a request for crime scene photographs. After he filed suit, the FBI claimed that it did not have any crime scene photographs. This statement was false. Ultimately, the FBI released more than 150 crime scene photographs to Weisberg. During the same case, Weisberg discovered evidence that in the FBI's own documents that an FBI supervisor named Long had kept a tickler file on the King assassination. A tickler is a file containing extra copies of documents kept at hand so it can be immediately retrieved. The FBI first denied that such a tickler had been kept, then it claimed it could not locate it. After a long period of resistance, the Justice Department finally located the Long tickler exactly where Weisberg had suggested they look for it. When finally located, most of the file had been gutted. Weisberg's suit on the King assassination documents lasted 15 years. He obtained approximately 60,000 pages. If the same suit were filed today, I believe that he would get only about 1/4 of what he obtained in the late 1970s and early 80s. These stories that I have related are unusual only because the requesters actually went to court to fight the CIA and FBI. Most requesters cannot afford the time or money to litigate their FOIA request against these agencies. You might be tempted to conclude from the general absence of litigation that the FOIA is working just fine. The opposite is true. The FOIA has been severely damaged by the 1984 amendments eliminating access to CIA operational files and by the 1986 amendments to Exemption 7, which applies to law enforcement records, as well as by a string of decisions in the Supreme Court and the United States Court of Appeals for the District of Columbia, which have greatly expanded the amount of material which can be withheld from the public. Let me add that while it is important to have obtained the public pledges from CIA Director Gates and FBI Director Sessions, which you heard today, if you support the release of the records, you must also ensure that you have the support of other agencies, including the Department of Defense, the Treasury Department, the State Department, and such divisions as the Secret Service and the National Security Agency. I wish to caution that while I think this legislation will result in greatly enriching our fund of knowledge about the Kennedy assassination and the official investigations of it, at least if modified along the lines I suggest in the attachment to this statement, I do not believe that there is likely to be any smoking gun which will solve the case. Rather, this legislation must be defended on the ground that the American people have a right to the fullest possible disclosure so they can make of it what they will. It will take much time to read, analyze, and understand the information released. Whether it will lead to the resolution of any controversies which beset this subject remains to be seen, but it is a course which cannot be avoided. The American people want to know the details of their history, however painful and puzzling it may be, and that is their right. The proposed legislation has both strengths and weaknesses. I am attaching to this statement a detailed discussion of the joint resolution, which includes a number of recommendations for change. To briefly summarize, the major provisions of the bill include a definition of assassination materials, the composition of the review board, and standards for the postponement of the release of information. The standards for postponement are critical because they determine the amount of material which may be withheld. Before discussing the limitations on the term assassination material as related to the assassination of John F. Kennedy, I note that this section excludes records on the assassinations of Senator Robert F. Kennedy and Dr. Martin Luther King, Jr. The House Select Committee on Assassinations conducted an extensive investigation on Dr. King's assassination and concluded that his murder probably was the result of a conspiracy. Public belief that Dr. King was killed as a result of a conspiracy and that his crime remains unsolved is widespread. The alleged assassin, James Earl Ray, denies that he shot Dr. King. Unless the importance of historical issues is to be determined by whether a movie has been made about them, there is no justification for excluding the King assassination records from this legislation. The assassination of Senator Robert F. Kennedy is equally the subject of profound controversy. Recently, a group of distinguished citizens has submitted a lengthy petition to the Los Angeles County Grand Jury to investigate evidence that the Los Angeles Police Department engaged in willful and corrupt misconduct in its investigation of Senator Kennedy's assassination. In support of these charges, the group submitted more than 800 pages of exhibits, mainly derived from the Los Angeles Police Department's own files, which document its charges that the LAPD destroyed crucial items of evidence, ignored material evidentiary leads, cannot account for important missing evidence, engaged in a cover-up of its failures, and failed to conduct a thorough investigation of the crime. The records of federal agencies and congressional committees relevant to Senator Kennedy's assassination should also be included in this legislation. The term assassination material is broadly defined, but it falls short of ensuring that scholars will have all of the documents which they need in order to properly study the subject. It should include policy documents which provide the context of decisions in the Kennedy administration which may shed light on the assassination. It should include, as it presently does, all documents obtained or created by any previous official investigation. It should include materials on those persons who have figured in previous official investigations, state, local, or federal. Because no one can predict in advance what new avenues of study where new avenues of study may lead, or what they may produce. The definition should be flexible enough to provide scholars with those materials reasonably calculated to shed light on the assassination or its investigations. Finally, it should also include information on agency operations and functions which may be relevant to the study of the assassination. The current provision defining assassination materials contains an exemption for personnel matters or other administrative affairs of a congressional committee, the Warren Commission, or any entity within the executive branch of government. I strongly oppose this exclusion. The Warren Commission records on this subject have been publicly available through the National Archives for many years and should not now be made secret. The work of prior commissions and committees is a perfectly legitimate subject, but it has been the subject of some secrecy which has impeded the public's right to know. In particular, the staff of the House Assassinations Committee, with the exception of its General Counsel and Staff Director, G. Robert Blakey, pledged an oath of secrecy about their work. Blakey has published a commercial book about the committee's work and is quite public and outspoken about it. Because of the secrecy oath, others who are quite knowledgeable about the committee's work have been silenced. The public has been denied their views and their information. In this regard, I would urge the insertion of an additional provision in this legislation which would rescind any secrecy oaths taken by the staffs of any previous congressional or executive branch committee or commission. This provision could also be used to prohibit the release of information regarding a very troubling incident in which the House Select Committee discovered that its most sensitive files on the Kennedy assassination had been rifled by a CIA liaison officer assigned to assist the committee. According to published accounts in the Washington Post, this officer, Regis T. Blayhoot, surreptitiously entered the safe reserved for physical evidence of President Kennedy's assassination, including autopsy photos, x-rays, and other articles, including the so-called magic bullet that allegedly wounded both Kennedy and Texas Governor John Connally. According to the Post, Blayhoot was given several polygraph examinations. He was asked whether he did it, and according to one source, he flunked that. He was asked whether anyone had ordered him to do it, and he is said to have flunked that question too. Materials regarding incidents of this kind should be fully available to the public. A second problem with this legislation is that it proposes to exclude from the review board anyone who has had, quote, previous involvement with the investigation or inquiry relating to the assassination of President John F. Kennedy. I believe this is too broad and should be limited to the involvement in prior official investigations. Having a panel of Kennedy assassination agnostics might have some idealistic allure, but the public is unlikely to be persuaded that the government intends to disclose all pertinent materials if the panel does not include experienced and knowledgeable Kennedy researchers. A third and critically important area that needs refinement is the standards for postponement of disclosure. Particularly significant is the need to narrow the definition of the term intelligence source and the term intelligence method. Virtually all information in an intelligence agency document can be withheld under these terms. Intelligence source must be defined to make it clear that it does not include sources who have been the subject of widespread publicity that is tantamount to official acknowledgement, and sources who are willing to have their identities disclosed, and sources who cannot reasonably be expected to suffer death or serious bodily harm if their identities are disclosed. Similar restrictions must be put on the term confidential source. With respect to intelligence methods, it must be made clear that this term does not include outmoded methods, methods which are known to the public, or methods which may be commonly deduced. Nor should it include methods that are known to hostile intelligence services. New legislation is needed. Half measures will not do. If this legislation does not succeed in substantially clearing the air, if it does not convince the public that nothing of critical importance to our understanding has been withheld but for the very best of reasons, then public cynicism about government will continue to increase. I ask that additional comments be placed in the record.
They'll be included in the record. Thank you very much. Professor May?
Thank you, Mr. Chairman. You have a statement from me, and with your permission, I will abridge that.
That's fine. It'll be in the entire statement will be included in the record. Thank you.
And I need to begin by saying that I am not an expert on the issue that is to be investigated here. I am simply a historian who's had some experience dealing with sensitive government records, and it's simply from that background that
you're eligible for the commission then, according to Mr. Lassard.
I meet the
test.
No
previous involvement.
And my comments on the bill are mostly cautionary. I question whether any legislation can achieve all that this bill seeks to achieve. And I question giving to a court-appointed review board the broad responsibilities that are assigned it by this act. I believe that a review board differently selected with a more limited mandate could do a better job. Now, the first cautionary point concerns the aim of clearing up doubts about the Kennedy murder. Even if every bit of relevant documentation becomes public, it will not yield a story that all Americans will accept. And why should it? Though we now know just about everything about the Pearl Harbor attack, new conspiracy theories continue to be woven. One of the latest, as Senator Cohen remarked earlier, has Winston Churchill as the villain. Despite a century of research, new theories still appear about conspirators helping John Wilkes Booth kill Lincoln, and the chances are that the same will always be true for Oswald and Kennedy. The chances of clearing away all doubts are lessened by the fact that every bit of relevant documentation will not be released. The bill itself speaks of protecting secret agents and intelligence sources and methods. It speaks also of privacy rights, and even if those are narrowly construed, much material by these criteria would have to remain secret. In fact, still more material may be kept from the public. This bill refers only to protecting the privacy of living persons. If the review board yields to human feelings, it may extend protection to families and friends. Suppose, for example, that the board sees raw FBI files recording old accusations against some Cuban Americans. Even if persons are dead, anyone ever connected with them could suffer should the accusations become public, could even have their lives in danger. If the review board suspects that the accusations were malicious and false, won't it choose to leave the file secret? Also, it has to be assumed that some files will turn out to have been lost or destroyed inadvertently. The proposed review board would thus have to confess not only that it chose to leave some material under wraps, but that other material is simply missing. Would spinners of conspiracy theories take the board's word? Would they not instead accuse it of colluding and concealment of smoking guns? The review board would meanwhile be under pressure not to let privacy rights or other considerations inhibit release of documents. Investigative reporters, writers, docudrama producers would hammer at it, So would scholars, including many interested in subjects other than the Kennedy murder. So would others with axes to grind. Some material sought might have only a remote relationship to the murder. The clamor would be no less ferocious. How much of the central files of the FBI and CIA would have to be opened to persuade disciples of Mark North or Mark Lane or Oliver Stone that neither FBI nor CIA officers participated in a murder plot? The review board would surely be urged to pursue data on the possible involvement of right-wing extremists. Obvious items would include not only FBI files but also tax returns. Imagine the scope of possible documentation if, in fairness, the review board also sought data on financial transactions by individuals associated with Vice President Johnson. I forecast, in other words, that new evidence will not dispel conspiracy theories. At most, it will curb some of the more adventurous theorizing. I also forecast that if release of the evidence is managed as this bill proposes, one of two results will follow. If the review board yields to outside pressures, it will conduct a fishing expedition. Much embarrassing and possibly harmful information will be made public. Alternatively, the review board will resist pressure. It will define its mandate narrowly. It will be prudent in what it reveals. It will then be accused of a whitewash. The latter result could make matters worse rather than better. Suspicions could be fed rather than allayed. There may, however, be a better means of doing what needs doing. The current bill would have the review board and its executive director examine all materials to be released. They would be charged with ferreting out undisclosed material, and they would have effective responsibility for deciding what would and would not be released. An alternative would be a bill simply enjoining the holders of records to identify and locate materials that, in the language of the current bill, in quotes, relates in any manner or degree to the murder of President Kennedy. The injunction would apply to all congressional committees and all executive agencies, including the CIA, the FBI, the Secret Service, and the National Archives. The bill could direct these record holders to make the materials public. It could specify that the only materials to be held back would be those itemized in the current bill: agents, intelligence sources, and methods, etc. Where legislative writ does not run or is disputable, a statute could urge voluntary action. The current bill asks such cooperation from state and local agencies and foreign governments. A statute that sought to avoid constitutional disputes could ask the same of the President regarding records of the White House and the Executive Office. This alternative bill could require or request public reports describing materials withheld from release, their characteristics and quantities, the general reasons for non-disclosure, and plans for eventual release. A review board could be created with a limited and more workable mandate. Its first duty could be to review record holders' guidelines. These might well differ from agency to agency. Procedures for searching National Security Agency files or communications intercepts might not be the same as those for searching the much less voluminous files of CIA stations and headquarters divisions. After all, the NSA collects miles of tape every day. The volume of documentation there is enormous. And the board could try to ensure comparative uniformity in the diligence of searches. The board could try also to ensure comparative uniformity in definitions of what is to be withheld. It might urge, as the bill now suggests, that the intelligence sources and methods criterion apply only to sources and methods in current use, not just to any ever used. The board's second duty could be to scan materials that record holders proposed actually to withhold. The board might question record holders' decisions. If so, it could ask that the agency or committee think again. If differences continued, the board could appeal to the President, or for congressional documents, the President of the Senate or the Speaker of the House. In a final public report, the board could describe any still unresolved differences. While the description would necessarily be in generalities, the issues would become publicly known. The broad purpose of the board's report would be to validate the record holder's non-disclosure decisions. Such a review board could be selected by comparatively traditional methods. Nominations could be asked of the American Bar Association, the American Historical Association, the American Political Science Association, or kindred bodies. Appointments could be made by the President by and with advice and consent of the Senate. Unless the quantity of material withheld proved to be much larger than I would expect, the review board could be kept small. It could probably manage with a minimal staff. I believe that such an alternative statute would accomplish all that can be accomplished. It would leave the onus for release or non-release of records on those already familiar with the records. Committees of Congress would make rules for their files, the President, the heads of departments, the directors of Central Intelligence and the FBI. The Archivist of the United States would make rules for theirs. This alternative statute would limit the powers and responsibilities to be thrust on an untried and potentially vulnerable review board. It would create a board with the assignment only of checking the coherence and consistency of criteria for disclosure and non-disclosure. Since your invitation to testify included questions reaching beyond the current bill, I take the opportunity to respond quickly to that concerning general declassification policies. I believe the procedure I just outlined could be applied much more widely. A statute could declare that all government records more than 30 years old would become public unless the originating agency could show specific cause for continued non-disclosure. A board or commission appointed by the President with the advice and consent of the Senate could have authority to review all such materials and to question or appeal instances of non-disclosure. This approximates practice in the United Kingdom. In conclusion, I repeat the warning against expecting any legislation to create a consensus and thereby, as the bill proposes, to contribute to the trust of the people in their government. Inventors of conspiracy theories will always be more ingenious than assemblers of evidence. The immediate result of releasing records will be to provide grist for the theorists' mills, even if everything were released tomorrow. It would take at least a decade for researchers to sort the newly released materials. In the meantime, conspiracy builders would be picking out those bits and pieces of evidence that suited them. In the long run, release of documents will get us closer to the truth, but as Keynes observed, that long run probably stretches beyond any of our lifetimes. Thanks.
Thank you, Professor. Professor Theo Harris.
Very good. Chairman, let me also abridge my statement for reasons of time.
The entire statement will be included in the record.
In contrast to Professor May's cautionary note, let me say I commend the legislation currently before the committee. I do so not because I think that the legislation will resolve the question of who assassinated John Kennedy or will put to the end the various conspiracy theories, either confirming or refuting them, but because I think it addresses, as Senator Boren stated this morning, an underlying concern that explains both the popularity of Oliver Stone's movie and the series of books that have been published this last season that relates, I think, to public suspicions that I think fall into two categories. That federal officials have not made available all government records relevant to the assassination, or two, that have heavily redacted the records released under FOIA. There is reason to believe that all relevant government records pertaining to the Kennedy assassination have not been released and cannot be precisely identified by persons outside the executive branch. It might not be the case that all such records were filed under specific names and programs. The federal intelligence agencies, for example, in the recent past instituted separate records procedures to safeguard their most sensitive documents. As I understand Senate Joint Resolution 82, this inability to identify all relevant records is addressed, as well as how or where they might be filed. In its requirements mandating that executive agencies make available to the review board all assassination materials, even if uncertain if a record is assassination material, in its authorization of the executive director to inquire as to the existence of further records, and then recommend the review board to subpoena such records in the event of denial. Properly placing the burden of ensuring the accessioning of all Kennedy assassination records on agency officials who are most knowledgeable about their agency's records practices, SJ Resolution 282 further enables the executive director and staff to identify additional records learned through a close reading of cross-references in these available records. Section 6, moreover, addresses the companion obstacle to full disclosure, the discretion which the FOIA allows federal agency officials to withhold categories of information when releasing FOIA requested documents. Particularly during the 1980s, agency officials have withheld information clearly relevant to understanding the relationship of the agencies to individuals identified directly or indirectly with the Kennedy assassination. Administrative and legislative changes encourage such non-disclosure, notably President Ronald Reagan's 1982 classification order, legislation of 1984 totally exempting CIA operational files from disclosure, and legislation of 1986 authorizing the FBI to withhold and deny the existence of FBI informant files. Section 6 dovetails FOIA's executive provisions, but at the same time introduces a stricter non-disclosure standard to require release, to quote from that section pertaining to intelligence agencies, unless the threat to the military defense, intelligence operations, or conduct of foreign relations of the United States posed by its disclosure is of such gravity that outweighs the public interest in its disclosure, or that invasion of privacy is so substantial that it outweighs any public interest in disclosure. My skepticism about agency practices in withholding documents, moreover, is based on my experiences as a frequent user of the FOIA. I recognize that this is not the proper forum for reviewing how federal agencies have processed FOIA requests, but I've included in my statement 2 examples that explain my skepticism. These examples, I think, both confirm what has been my experience, that the culture of the intelligence agencies encourage agency officials to interpret FOIA exemptive provisions broadly and at times capriciously, but at the same time, and this might be striking given those examples, that more senior FBI officials and other agency officials will release even embarrassing information in those instances where their decisions are subject to critical scrutiny. The review board procedure, I think, addresses this problem, and I commend it to the committee. In conclusion, let me make one point that was raised by Senator Cohen this morning of the congressional panel, and that I did not include in my statement, and that relates to the time frame of the review board. In contrast to Professor May, I don't think that the inquiry that is mandated by the legislation will require a 10-year period. And I suggest that the committee might look into a similar experience involving the review of intelligence agency records, and that is the National Archives FBI Record Appraisal Project staff that was created in response to Judge Green's 1980 order directing the FBI and the National Archives to develop a records plan that would ensure the preservation of FBI files of historic value. Now, that was a complicated problem that the National Archives and the FBI had to address, and related to a quite different question, that is to identify records that were to be preserved, and by not identifying the records to result in the destruction of records. And it was involved in litigation where you had the court reviewing the plan as well as attorneys coming in and challenging the submission presented by archives and the FBI. But my suspicion is that the 2-year period would suffice to incorporate the review procedures identified in the legislation. And I think you might consult with archives and the FBI about the disposition of that particular records plan. Thank you, Mr. Chairman.
Thank you all for your very excellent statements. Let me ask if you've heard this morning that there probably is an executive order in preparation over at the White House or somewhere. If that came out, was a good strong one that restored some of the processes we had going clear back to President Kennedy's day when he had set some release policies for information. Would that be adequate? Would this still be necessary? None of you are really hot for this for this particular panel, I gather, and think it really has some serious deficiencies. And I don't necessarily disagree with you. I think we have to consider all these things. But if an executive order came out that was a good, strong executive order, would that take care of most of the problems?
No, I don't think so.
Lazar?
No, I don't think so. I mean, immediately the problem of there would be no. I don't know how we. It's a little hard to prejudge it since we've only heard about it. We haven't seen it. But I would suspect that an executive order would not provide any mechanism for identifying all of the records that people think pertain to the Kennedy assassination.
Are we going to maybe have that same problem even with this commission?
You will, but you have a very important provision here giving the board the subpoena power and the power to make inquiries, and I think that would obviously be missing from the executive order.
Professor May?
Well, I believe, sir, that some kind of legislation is needed. I don't think an executive order is adequate, probably, in part because I think it unlikely that you would get the same degree of cooperativeness from all agency heads that you had evidenced by Director Gates this morning. In that attitude, there are parts of the government where that attitude does not prevail, and I think you really need a piece of legislation that enjoins the release of documents. And I believe, in addition, that there is great merit in having some kind of a board that can review decisions to withhold material. As I said, I think that should be our general practice, not peculiarly for this case, but for all historical records.
Professor Theo Harris?
I too share very strong reservations about the executive order because I think it raises again what has been the problem that explains why the legislation is currently being considered. Namely, it gives great discretion to executive agency officials to determine the release of information and the criteria for the release of information. The value, I think, of SJ Resolution 282 is it provides the not only tighter criteria, but you have this kind of external oversight, which I think will ensure both a greater release of information as also restore public confidence that what's not being done is withholding information for either bureaucratic reasons or because of more sinister motives. And thus I think I would pursue the avenue that is implicit in SJ Resolution 282.
Yeah, Mr. Lazar, you referred to the need to release more policy documents in particular areas during the Kennedy and Johnson administration as a means of broadening the historical context of the assassination. Now, this wouldn't get into all of those. The proposed legislation here would not get into all of those policy areas necessarily. You think that's necessary, or are we off in a real broad area here that's going to require, you feel that we're never going to know the real answer to the assassination unless we put it in its historical context with regard to policy and so on, but that really broadens this out tremendously.
Well, it broadens it. I don't know in terms of volume of documents that the volume is all that great, but and the areas, there are two or three principal areas, one being Vietnam War policy and the second being Cuban policy, particularly Bay of Pigs policy, and maybe a third area relating to organized crime. Those would be the three primary areas, and I think that because of the issues that have been raised by writers and by Oliver Stone, that you've simply got to deal with those issues.
Yeah. If we went along with having the board appointed by the president, which has been suggested here this morning, would that undermine public confidence in board decisions, Theo Harris? Sure.
I think so. I think there is this doubt about the federal government that is reflected in the popularity of the books that have been published, particularly this book by Claire Zerbel, a self-published book that it was on the New York Times bestseller list for 9 weeks. I mean, there surely is a sense out there that the government is not to be trusted. And to have the executive branch determine the composition of a impartial committee might not have the purpose that I think is addressed by the legislation, that is to restore confidence that everything that is there is going to be released and that there are no sinister motives in withholding information. There are legitimate national security or law enforcement reasons not to release
Professor May, what do you think? You think that would undermine confidence?
I don't think so. That is, I think if it involves both the executive and legislative branches, so I would strongly favor confirmation, not simply executive appointment.
Okay.
And I don't think that the mechanism of court appointment is going to seem that necessarily that more reassuring than the standard process of appointment with confirmation. And I think the best way of getting some degree of public confidence in the panel is the one I suggested of having the panel, or most of its members, chosen from people who have been nominated by professional associations. And you might, I mentioned the American Bar Association, the American Historical Association, the Political Science Association. You might extend it, for example, the American Medical Association, and a list of people. I think it would have to be not their choice, a substantial panel of possible nominees that would be chosen.
Lazar?
Yes. I think that I agree with both of them that executive branch appointment, I think, would probably be perceived as an inadvisable method, and in particular in this case because at least if made by the current president, he was the director of Central Intelligence Agency at the time of the Church Committee investigations and the House Select Committee investigations, was personally involved in matters relating to those investigations. Secondly, there was an allegation in Nation magazine several years back that he had personally been involved in a cover-up of assassination information. So that I think that under the circumstances it would be far better to have the judicial panel appoint. If presidential appointment were determined, I think it should be done in conjunction with Congress.
Professor May, just one more question. You suggest sort of an alternative approach which gives the record holders, in effect, the responsibility for producing the information, as I heard you. But don't you think that would be viewed by many in the public as too trusting or lacking in accountability? Because practically speaking, the agencies will make the first cut. It's up to them to do the retrieval, and how will anyone ever know what is not produced for release or review?
Well, I suggested, sir, that the board should have as its first responsibility working with the agency so that there are comparatively uniform guidelines, so that what is defined and what is to be included and what not included is fairly generally known. And then within that definition, the agency would have to expose to this board whatever it elected to withhold and explain why it had done so. I think that would. May I, sir, just one? Sure. Because I want to correct a misimpression. I did not say, and don't mean to say, that I think it would take 10 years for a board to produce the material. I think that could be done very quickly. But I think it will take an absolute minimum of 10 years for people to begin to sort out what is significant and what is not significant, what is new and what is illuminating in the new material that's released. I think that's an absolute minimum, and I think Professor Theoharis would agree with me on that.
And it'll probably open up a lot of new areas that we still have questions on, which you all three pointed out.
Could I respond to your question?
Certainly, go ahead.
Well, I'd like to come back to the point I made in the formal statement. It seems to me that one of the problems that underlay the doubts that exist is that the agencies have records that are not being released. And the difficulty is to identify those records, not knowing how they were filed and how they were maintained. The value, I think, of the review board is that, and I'm speaking simply from my experience researching FBI records, is that upon receipt of a category of records, the reviewer of those records can identify whether other records were created. If you look at my Appendix B, and I use the example of that summary memorandum on Henry Grunwald, within that you have identified records by file number. And so it allows reviewers to identify additional records that might not have been released. And so I think the value of your procedure, as cumbersome as it is that it ensures that you can obtain all relevant records because of the option of going back and asking for more and even subpoenaing if they do not deliver them. So I would like to retain that provision of legislation.
Okay. Thank you all very much. We're going to have to end. We may have additional questions for you to be submitted. We'd appreciate an early response so we can include your responses as part of the record. Appreciate you being here today. Thank you very much.
Thank you.
Thank you. Hearing will stand in recess.
C-SPAN, the cable satellite public affairs network, and its companion network, C-SPAN 2, are privately funded to serve the public by America's cable television companies.
Here's an update of our program schedule, and please note all times listed are Eastern times. Just ahead, President Bush shares his views concerning federal aid to urban America. After that, congressional leaders speak with reporters on that very same subject. At 1 o'clock, we'll